ಇದು ಆನ್ ಆನ್ ಆಗಿದೆಯಾ?
ಆನ್ ಆಗೈತೆ.
ಫುಲ್ ಬರಲ್ಲ?
ಆನ್ ಆಗಿದೆ, ಆನ್ ಆಗಿದೆ. ಅಲ್ಲಿ ವಾಯ್ಸ್ ಬರ್ತಾ ಇತ್ತಲ್ಲ. ಆನ್ ಆಗಿದೆ.
ಫುಲ್ ಬರಲ್ವಾ ಸ್ಕ್ರೀನ್ ಅದು?
ಬರುತ್ತೆ ಸರ್, ಅಲ್ಲಿ ಜಾಯಿನ್ ಆಗಿಲ್ವಲ್ಲ.
ಇಲ್ಲೇ ಕರೀತಾರ?
ಬರ್ಬೇಕಾಯ್ತಲ್ಲ.
Long date ಕೊಡಿ ಅಂದ್ರು madam. My lords, the matter is settled, my lords. Kindly have it tomorrow, my lords. Tomorrow. Any adjournment? These two, page 6, serial number 44 to 44 and 45.
Lordship, I pay for the petition.
My lord,
Okay.
serial number 2 in this case, my lord.
45. Lordship. Serial number 45.
Reporting settlement.
I seek a short adjournment because my senior has taken severely ill, Your Lordship. I've been informed this morning. I informed the other side as well. First week of January is fine with us, Your Lordship.
It is posted either to report settlement or to address argument.
Your Lordship, I have
But they
informed.
choose among two
I have informed the other side as well.
on adjourning the matter.
No, Your Lordship. I undertake to submit a report by the next date. It's a little urgent.
Time also you have undertaken.
No, Your Lordship.
What is the sanctity that could be attached to your undertaking?
No, Your Lordship. Even the other side have been
If you are
informed.
not honoring your own undertaking, who else will honor?
I humbly beg before Your Lordship.
No, sir, sorry. You address the argument.
Your Lordship, it's
Reporting is not,
Your Lordship.
next.
Serial number 46.
Yes.
This one, page 1.
Let's have one submission, Malats. In list number 2, Malats, serial number 6, Malats. I need an adjournment, Malats. Need to seek instruction with my client, Malats. Serial number 6, list number 2.
Serial
Pray
number
for some
6.
time, please, Malats.
Why it is listed?
It has been listed for IA 120 for hearing on interlocutory application.
Can you not argue that?
But I need to take some instruction with my
What
client, Malats.
instructions on that application?
But he has to come before the court, Malats. I mean, he has to come before the office and
For what purpose?
he has not come before the office, Malats, since
Then
2000.
without instructions, how you filed that
Because
application?
after filing of the after filing
How
of,
you filed that application without instructions?
well, he had come before the office in 2018. After that, he has not come before the
So
office.
every day he has to give instructions?
Not necessary, my lords, but after that, he has not.
I will take it very seriously.
Please, my lords. That's one last chance may be given, my lords.
Next.
That's please, my lords.
Page 1.
Hmm.
Complaints of office objection for person, serial number.
You should have some common sense, sir.
That's
That application is just to a formal application seeking leave of the court.
please,
And for that you want instructions from the court.
please, my lords. I'll argue, my lords.
Serial
Yes.
number 1.
The appellant,
Ganesh Nag BV.
I pray for 3 weeks' time, my lords.
Please for time.
Serial number 2, Sridhar Murthy G. G. Sridhar Murthy.
Observe no representation.
3, Hari Prasad MB.
Observe no representation.
4, Manjunatha LK.
For 2 weeks time.
Please time.
5, Shashidhar KN.
Observe no representation.
6, Ashok Kumar Shetty K.
Observe no representation.
Non-compliance for second time, serial number 7, Dorai Babu.
Appear for the petitioner, my lord. Course of the day we complain.
Please for time. Yes.
Serial number 8, Narayan Swamy.
Observe no representation.
9, Government Advocate.
Pray for some time. my lord.
Please time.
Non-compliance for that time, serial number 10, Cyril Prasad.
Please respond. Done. Next. ಅದು ಫಸ್ಟ್ ಒನ್ ಯಾವುದು? ಅಲ್ಲ, ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ at serial number 1. Learned counsel for the appellant is absent, no representation. The counsel's submission regarding office objection at serial number 1 is accepted. Objection is ignored. The submission regarding the office objection at serial number 4 is rejected. Counsel for the appellant is required to comply with the office objections. The appeal is of the year 2020, listed for the third time for complaints of office objections. I do not find any reason to adjourn the matter, rest finally as a last chance. Next.
Serial number 11 for order, government advocate.
Lord, the respondent is dying. The sole respondent.
So I'll dismiss. As per police report, respondent expired on 7/9/2022. Appeal is awaited, hence the same is dismissed as awaited. Yes.
12, Mahesha M. Notice is not served.
Counsel for the appellant is absent, no representation. To furnish fresh address, correct address, and PF for issuance of notice. Next.
13, Arjun Airport.
ಇದು same. Next.
14, Vijay Shetty.
Give a fresh address, ready to PF, counter file ಮಾಡಿ, ready,
PF, password.
reissue ಅಂತ ಮಾಡಿದ್ರೆ file ಮಾಡ್ತೀವಿ.
ಮಾಡಿ ಫೈಲ್ ಮಾಡಿ ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ತೋರಿಸಿ. ನೆಕ್ಸ್ಟ್.
15, John Joseph.
Appearing for the appellant, my lords.
India Anirudh.
I've taken fresh steps in the counter, my lords. I'm filing the copy of the order.
Counsel for the appellant submits that he has paid PF for issuance of notice to respondent number 1. That is to verify if PF is paid, issue notice.
All are connected, my lords.
15.1,
Yes, ma'am. All three are connected, my lords.
all the three.
All three are connected.
Yes. Issue notice. Next.
Obliged, ma'am.
16, EI Sanmati.
I appear for appellant, my lords. Needful is done, my lords.
Counsel for the appellant
Paid.
submits needful is done. Office to verify if PF with correct address is furnished, issue notice to respond. Only 15 al tagoli. Counsel for the appellant submits that he has paid PF in all the 3 cases for issuance of notice to respond number 1. Yes. Next.
Serial number 7,
Obliged.
Vigneshwara
Appearing
U.
for appellant, my lord. Needful done, my lord. Copy.
Early the needful done.
Yeah,
What is the
proxy counsel, my lord. I'm told that needful is
Passover.
done, my lord. Yes, ma'am.
These 2, serial number 1.
I'm for the appellant, my lord.
Yes. ಯಾವುದು serial number?
1. This is serial number 1.
You have not yet received the report.
ಯಾವಾಗ, when it was issued?
December 3rd. December.
I'll verify, my lords.
You instruct to execute it. Await police report. Next.
Serial number 2.
Await police report, sir.
Appearing for
Much
the-
obliged, my lord.
2, GB Nandish Gowda, memo for
Appearing for the appellant. my lord.
Yes.
We have
Counsel
filed
for the
memo for
appellant
withdrawal from the.
filed a memo seeking permission to withdraw the appeal. Memo is placed on record. Appeal is dismissed as withdrawn. Yes.
serial number 3, government advocate.
My lord, in this case, my lord, they have filed the report today morning. They seek time for,
No, they have returned the memo.
yes, my lord.
As per police report,
My lord, they
the
have not,
BW issued against respondent is unexecuted as
not executed, my lord. They need some more time to execute. Again, maybe reinstatement.
ಅದರಲ್ಲಿ serial number 2 ನಲ್ಲಿ ನಂದೀಶ್ ಗೌಡ ಅಂತ ಅದನ್ನು ಸೇರಿಸಿ.
He's not found in that address and also, my lord, and he's not using the same mobile number also. Somebody else is using that mobile number.
Issue NBW against respondent. Issue NBW. Next.
Serial number 4, Jagdish HP, memo for withdrawal.
Counsel for the appellant petitioner filed a memo seeking permission to withdraw the petition. Memo is placed on record. Petition is dismissed as withdrawn.
Hearing on IA. Serial number 5, Pradeep Kumar.
Appellant is absent, no representation. IA 1 of 18 is filed seeking condonation of delay of 7 days in preferring the appeal. IA 2 of 18 is seeking leave of the court to prosecute the appeal for the reasons stated in the affidavit petition and of IAs 1 and 2 of 2018 are allowed. Delay of 7 days is condoned. Leave is granted to prosecute the appeal. List for admission.
Serial number 6, Nagaya, Vijay Kumar TM.
Please, Max. This is an appeal arising out of the judgment of the court in CC number 5138 of 2016. This is with respect to check bounce case, Manoj. That's the complainant and the accused are friends known to each other from a very long time. That's the complainant has
On
lent.
IA 1 of 2020, seeking leave of the court to prosecute the appeal for the reasons stated in so and so. IA is allowed, leave is granted, list for admission. IA is allowed, list
Please.
for admission.
Serial number 7, Matthew PM.
ಇದಕ್ಕೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬೇಕು ನಿಮ್ಗೆ.
That's after filing.
ಫೈಲ್ ಓಪನ್ ಮಾಡಲ್ಲ, ಅವ್ರು ಬರ್ಬೇಕು, ನಿಮ್
Manoj.
ಮುಂದೆ ಫೀಸ್ ಕೊಡ್ಬೇಕು, ಆಮೇಲೆ ಯು ವಿಲ್ ಓಪನ್ ದ ಫೈಲ್.
I've
You
got.
are still a youngster, sir. You are not a senior counsel.
No, my lords.
Don't cultivate that habit.
No, my lords. Because my
Yes,
senior,
next.
because my
Next
senior
about-
has to take.
I don't want any explanation from
Yes,
you. I can understand.
Please, my lord.
Serial
Yes.
number 7, Matthew PM.
For the appellant, your lordship.
Counsel
This is
for
a
the
matter arising
appellant
out of 138 NI.
On IA 1 of 18 and 1 of 19, taking leave of the court to prosecute the appeal and to condone the delay of 4 days in preferring the appeal for the reasons stated in so and so. IAs are allowed. Delay of 4 days in preferring the appeal is condoned. Leave is granted to prosecute the appeal. List for admission.
Serial number 8, Narendra Gowda.
38 proceedings.
Third learned counsel for the appellant on IA 1 of 19, leave, ಅದೇ same similar ಹಾಕೊಳ್ಳಿ. IA is allowed. List for admission.
9, Government Advocate.
40
Third,
days delay.
learned HCGP on IA 1 of 20, delay of 114 days condoned. Yes. Admission.
Serial number 10, Government Advocate, Venkatesh Somareddy.
Same, 73 days delay condoned. Next
11,
11,
Government.
allowed, 41 days delay condoned. Next,
12, Muduraj.
Appearing for the appellant, my lord.
third learned counsel for the appellant on IA 1 of 19, IA is allowed, leave is granted, list for admission.
Serial number 13, Government Advocate, Pratik KC.
51 days.
Third, delay of 51 days condoned, list for admission.
14, Leeladhar HP.
Happy for the appellant, my lord.
Parab.
Appellant.
Third learned counsel for the appellant on IA 1 of 19, leave is granted, list for admission. ಅದು full ಬರ್ಕೊಳ್ಳಿ.
15, Bhadravati Siddeshwar.
Present no representation, IA 1 and 2 allowed, delay condoned, leave is granted, list for admission.
16, same man. Bhadravati
Same.
Siddeshwar.
Next.
17, Dijitri Baldare.
I'm appearing for appellant, my lord. Please delay condone, my lord.
Third learned counsel for the
And
appellant,
specially you grant
18, 58 days condoned, leave is granted for admission. Next.
special you grant, my lord.
Yes, IA is allowed.
18, G Narayan Rao.
Appellant in this case, 138 proceedings.
Third learned counsel, IA 1 is allowed, leave is granted, list for admission.
19, Arvind Babu PS, MB Ravi.
For the respondent, my lord.
I'm relying the judgment of the sum court, wherein this respondent is expired and appeal will not survive. You have the 394 million.
Respondent died
Also,
when?
I have furnished the copy of this. Last date, you have furnished, 13/12/2023, my lord.
13/12/23.
Relying judgment of the sum
ಕೊಡಿ
court,
ಏನದು ಕೊಡಿ
394 relevant param, my lord. Page 4, paragraph 5, my lord. Page 4, paragraph 5, my lord. The appellant party in person submit that before reporting death of the respondent, the written arguments was filed and therefore appeal will not abated. But the contention of the appellant cannot be acceptable for the reasons stated below as the section 394, 1 of CRPC, which reads abatement of appeals. Every appeal under section 377 or section 378 shall finally abate on the death of the accused. Every other appeal under this chapter, except appeal from sentence or fine, shall finally abate on the death of the appellant, provided that where the appeal is against the conviction and sentence of death of the imprisonment and the appellant dies during the pendency appeal, any of their near relatives may, within 30 days of so and so.
Yes. Then counsel for the appellant is absent, no representation. Then counsel for the respondent submits that the respondent had died 13/12/2024 and therefore the appeal is already abated. As placed for dismissal of the appeal. We place reliance on the decision of this court in GV Varadaraju versus B.R. Sudha. Date of disposal 29th March 2022. To content that on death of the accused, the appeal under section 377 and 378 will abate. Considering the submission made by the learned counsel for the respondent, appeal is dismissed as abated. Yes, dismissed as abated. Next.
Much of it.
Yes, Sachin.
The petition.
Heard, I is allowed, delay condoned, leave is granted, list for admission. Yes.
Gopal Singh. 77 days.
For the petitioner.
There is inordinate delay, 277 days. It will be heard along with merits. IA 1 of 19 is filed seeking condonation of 277 days in preferring the appeal. Since the delay is inordinate, IAs 1 and 2 of 19 are ordered to be heard along with the merits list for admission along with the applications. Yes.
Serial number 22, NK Siddeshwara.
Heard counsel for the appellant
Under section
on IA
38 of NIA.
For the reasons stated, IA allows, leave is granted, list for admission.
23, AV Gangadharappa.
Absent, no representation, IA is allowed, special leave granted, list for admission.
24, HC Shivramu.
Heard.
File is misplaced, your lordship may kindly have this matter tomorrow or day after tomorrow.
Okay, ನೀವು ಆ ಕಡೆ ಹೋಗಿದ್ದೀರಿ, ನೀವು appellant ಗಿದ್ದೀರಿ. Heard
ಸಿಗ್ಲಿಲ್ಲ
counsel for the appellant
ಅದಕ್ಕೋಸ್ಕರ.
on IA 1 of 19 for the reasons stated in so and so, IA is allowed, leave is granted, list for admission.
Please, grateful.
25, MJ Alva.
For the complaints appeal.
IA 1 of 20 for the reasons so
Wait,
IA is allowed, leave is granted, list for admission.
26, Prashant Chandra SL.
Counsel for the appellant is absent, no representation. IA 1 of 19 is especially for the reasons so and so, IA is allowed, leave is granted, list for admission.
7, Parmeshwarappa MB. 329.
Okay, ಅದು ಈ benefit. ಇದೆಯಲ್ಲ 27 ಅಲ್ಲಿ IA 1 of 2023 is filed under section 329 sorry. First ಗೆ ಬರ್ಕೊಳ್ಳಿ. The net counsel for the appellant is absent, no representation. IA 1 of 2023 is filed seeking condonation of delay of 329 days in preferring the appeal. Since the delay is inordinate, IAs 1 and 2 of 2023 are ordered to be heard along with the merits. Hence, list for admission along with applications.
28 Chandramouli PG.
Absent or representation, IA allowed, leave is granted, list for admission.
29
Trial
Nagaraja.
court record ಬಂದಿದ್ದು ಅದರಲ್ಲಿ call for.
Yes, Nagaraja.
Allowed, IAs 1 and 2 allowed, delay condoned, leave is granted, list for admission.
30 Government Advocate.
So 82 days delay.
Along with merits. Along with merits ಅಂತ ಹಾಕಿ. List for admission along with merit. IA
31 M Venkatappa.
absent, IA allowed, leave is granted, list for admission.
32 Pallava R.
Heard, IA allowed. Leave is granted, list for admission.
33 Government Advocate.
12 days.
Allowed, delay condoned, list for admission.
34 Chandrasekhara K.
Absent or representation, IA allowed. Leave is granted, list for admission.
35 MB Chandrachud.
Heard, IA is allowed, delay of 57 days in preferring appeal condoned, leave is granted, list for admission.
Which obliged.
36 KR Lingraju.
Absent or representation, IA is along with merits, inordinate delay.
37
Admission along with applications.
Ashok Kumar Shetty.
Absent, IA 1 is allowed, leave is granted, so and so. Next.
38 Nanjareddy PL.
Absent no representation, IA 1 and 2, delay condoned, leave is granted, list for admission.
39 Poonam DL.
Absent no representation, leave is granted, list for admission.
40 Vishwajit Rai.
Appellants.
Heard, and concept of the appellant, IA is allowed, leave is granted, list for admission.
41 YT Abhinay.
For the grant
Heard,
of
and
special.
concept of the appellant, IA 1 of 24, leave is granted, list for admission.
Serial number 42 for further argument. Shankar M Nayak, SR Jagdisha.
Abhinay IT. Abhinay IT. ಇದು ಬರ್ತಾ ಇದೆ. ಇದು ಬರ್ತಾ ಇದೆ. Yes. ಆಯ್ತು, ಅದೆಲ್ಲ ಆಯ್ತು, argument higher ಆಗಿದೆ. Next. ಎಲ್ಲರೂ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವರು ಮಾಡಿದ್ರು. You have already addressed the argument?
Yes.
Okay. What do you ask for? City then? Previously. Yes. Right. Continue. My answer to the other point is in the negative for the following reasons. It is the contention of the appellant complainant before the trial court. The accused had requested for financial help of rupees 1,60,000, promising to repay the same within 6 months. Accordingly, he had lent the amount to the accused on 6/4/2013. Towards repayment of the same loan, the accused had issued 3 checks dated 5/11/2014. One of the check is Exhibit P1 for rupees 1,60,000. The same was presented for encashment and it was dishonored. As there was insufficient fund in the account of the accused. The legal notice was issued calling upon the accused to repay the check amount. In spite of service of notice, he had not repaid the amount and thereby has committed the offence punishable under section 138 of NI Act. In order to prove this contention, the complainant examined himself as PW1 and got marked Exhibit P1 to seven. The accused has denied the incriminating materials and got examined DWs 1 to 4 and got marked Exhibit D1 to 8. DW3, the postman, has produced Exhibit C1 and 2. C1 and 2. On the basis of these materials on record, the trial court formed an opinion that the complainant is not successful in proving the guilt of the accused beyond the next. It is the specific contention of the complainant as per the private complaint that he had lent rupees 1,60,000 to the accused on 6/4/2013 and towards repayment of the said amount, the accused had issued 3 checks dated 5/11/2014. But strangely, Exhibit P1 is not dated 5/11/2014, but it is dated 25/11/2014. And it is for rupees 1,60,000. The complainant has produced Exhibit P3, the postal, the copy of the legal notice. It contains that the same is served on, same was deliberately evaded by the accused. The accused has appeared before the trial court, cross-examined PW1, stepped into the witness box and deposed as DW1 and also examined other witnesses and got marked with documents. It is the defense taken by the accused that 3 blank checks were forcibly taken by him by the complainant and there was no debt or liability which is enforceable. Therefore, the accused has admitted signature found on Exhibit P1 and under such circumstances, the presumption under section 118 and 139 of MI would arise. Once the presumption under 118 and 139 arises, the initial burden on the complainant gets discharged and the burden shifts on the accused to rebut the legal presumption. The accused has next part. The accused has pointed out that according to the complainant, the 3 checks were issued by the accused has issued 3 checks dated 5/11/2014. According to the complainant, Exhibit P1 is one of those checks. But Exhibit P1 bears the date as 25/11/2014. The accused has produced Exhibit D7 and the complainant has produced Exhibit D7 and 8, the other 2 checks for rupees 50,000 and 10,000 respectively. Even though these checks were produced by the complainant, the same were got marked by the accused. These checks do not bear any date. Under such circumstances, the contention taken by the complainant that the accused had issued 3 checks on 5/11 D checks dated 5/11/2014 is falsified. Moreover, when Exhibit P1, the check dated 25/11/2014 is for rupees 1,60,000. There is absolutely no reason as to why the accused issued Exhibit D7 and 8 for rupees 50,000 and 10,000 respectively. Next part. According to the complainant, he had issued the notice as per Exhibit P5 before presentation of the checks. This notice is dated 10/11/2014. That is much prior to presentation of the check. But strangely, no postal receipt or acknowledgement is produced by the complainant to prove that he had sent the check, sent the notice addressed to the accused, and the same is served on him. It is pertinent to note that Exhibit P5 check do not find a reference in the private complaint filed by the complainant. Next part. Exhibit P3 is the legal notice dated 13/11/2015, and Exhibit P4 is the postal track record according to which the article was booked on 13/1/2015. It was returned undelivered as door locked on 14/1/2015, and the article was delivered back to the address to the sender on 20/1/2015. Therefore, the notice was not served on the accused but it was returned as door lock. Even though there is a presumption under section 27 of the New Clauses Act, we verify regarding service of notice, when the same is addressed, properly addressed and sent through registered post, the accused examined DW3, the postman, who returned the envelope as door lock. This witness has stated that the notice could not be served on the addressee as the party has left the address. But strangely, DW3 was never cross-examined by the learned counsel for the complainant for the reasons best known to him. Under such circumstances, the evidence given by DW3 remains unchallenged. Rather, the evidence of DW3 is virtually admitted by the complainant. Under such circumstances, the presumption of law under the General Clauses Act gets rebutted. It is the contention of the accused that 3 checks with his signatures were taken by the complainant forcibly. In that regard, the accused has stepped into the witness box and deposed as DW1. He got marked Exhibit D1, the complaint against the complainant for having forcibly taken the checks. Of course, Exhibit D1 do not bear any date. However, the accused has produced Exhibit D2, the endorsement by the SHO Banaswadi Police Station, Bengaluru, for having received the complaint against the complainant. And as per this endorsement, the complaint was received in the police station on 13/11/2014. It is pertinent to note that even though the complaint as per Exhibit D1 is filed on 13/11/2014, Exhibit P1 check is dated 25/11/2014. That is much after filing of the complaint with the police. When the accused has taken a specific defense regarding the 3 checks referred to by the complainant, as the same are obtained forcibly, it assumes importance and the burden is on the complainant regarding assumes importance. And by producing Exhibit D1 into the accused is successful in rebutting the legal presumption under section 118 and 139 of an act. Even though the accused examined himself as DW1, nothing has been elicited from him during cross-examination to disbelieve his version. Once the accused is successful in rebutting the legal presumption under 118 and 139 of an act, the burden again shifts on the complainant to prove lending of the amount and existence of legally enforceable debt. The complainant has not placed any material to prove lending of the amount of rupees 1,60,000 as controlled by him. When the complainant fails to prove existence of legally enforceable debt, the accused is entitled for acquittal. I have gone through the impugned judgment passed by the trial court. It has taken into consideration the materials on record and arrived at a conclusion that the complainant is not successful in proving the guilt of the accused beyond reason. I do not find any illegality or perversity in the judgment passed by the trial court. Hence, it do not call for any interference by this court. Accordingly, I answer the point in the negative and proceed to pass the trial. Appeal is dismissed. Appeal is dismissed.
43, Venkatesha Sarbati, H.C. Shivramu.
Yes,
Only short point I was to answer about the charge.
yes.
Your lordship had expressed some concern, some doubt regarding the manner in which the charge was framed. Lord, kindly permit me about 15 minutes. I will read the two provisions, my lord, section 713(1)(d, on which, my lord, this case is. Then I'll take, my lord, to section 215. Your lordship have considered it in another
Not
judgment.
only charge, sir, even charge sheet.
Very well.
Yes,
So, my lord,
both charge sheet and charge.
eventually, my lord, what the accused will answer is the charge which is framed against him, is the bundle of facts which is posed to him by way of my lord, leading evidence. And your lordship have very well considered it. I was able to place my hands on a division bench judgment of my lord's, where my lord has considered 215, 464, and my lord Dalbir Singh judgment of 2004.
Yes.
I will take, my lords, I'll try to make an attempt on that. At section 7 of the Prevention of Corruption Act, what are the ingredients? Lord, I'll read section 7. Public servant taking gratification other than legal remuneration in respect of an official act. Whoever being or expecting to be a public servant accepts or obtains or agrees to accept or attempts to obtain from any person for himself or for any other person any gratification whatever other than legal remuneration as a motive or reward for doing or forbearing to do any official act or for showing or forbearing to show in the exercise of his official function favor or disfavor to any person or for rendering or attempting to render any service or disservice to any person with the central government or any state government or parliament or the legislature of any state or with any local authority, corporation, government, company referred to in clause C of section 2 or with any public servant, whether named or otherwise, shall be punishable with imprisonment, which shall be so and so. Explanation: expecting to be a public servant, gratification, legal remuneration, a motive or reward for doing. Explanation D, I will read, my lords. A person who receives a gratification as a motive or reward for doing what he does not intend or is not in a position to do or has not done comes within this expression. E, where a public servant induces a person erroneously to believe that his influence with the government has obtained a title for that person and thus induces that person to give the public servant money or any other gratification as a reward for this service, the public servant has committed an offense under this section. So, my lord, for the purpose of section 7, the ingredients are, my lord, well enumerated. Apart from all these ingredients, it touches upon the official function, exercise of official function. It touches upon, my lord, doing or forbearing to do any official act. it touches upon showing or forbearing to show any favor or disfavor. Not it touches upon motive or reward for doing or forbearing to do any official act. So, my lord, the question arises whether khata transfer, which is related to the bribe in this case, whether it touches upon that or not. But I'll answer that in a moment. But before that, my lord, may I take, my lord, to section 13(1)(d). (13)(1)(d), my lord, as it stood prior to the amendment.
Yes.
A public servant is said to commit the offense of criminal misconduct if he, by corrupt or illegal means, obtains for himself or for any other person any valuable thing or pecuniary advantage. That is clause 1. Clause 2. By abusing his position as a public servant, obtains for himself or for any other person any valuable thing or pecuniary advantage. Or clause 3. While holding office as a public servant, obtains for any person any valuable thing or pecuniary advantage without any public interest. Or then it is clause clause E. So, not for the purpose of clause D, there are 3 subclauses: subclause 1, subclause 2, subclause 3.
Yes.
None of these subclauses not relate to any official function. None of these subclauses relate to any official favor, disfavor, has performed, to be performed, any such thing.
Yes.
The only requirement for the purpose of section 13(1)(d), there are judgments to say that 13(1)(d), clause 1, clause 2, clause 3, all these 3 clauses are independent offences. But all these 3 clauses I just now read out, the distinction between 7 and 13(1)(d) is conspicuous absence about any relation to any work in 13(1)(d).
Yes.
Lord, this is, Lord, insofar as the offense itself is concerned.
Yes.
So, Lord, then, Lord, coming to 215 and 464, Lordships have read it a number of times. And also, Lord, the judgment is there, which my lords have been part of the division bench. 215 and Lord, the charge starts at chapter 17 of the CRPC.
Yes.
Charge, my lord, starts with is under chapter 17. Start with section 211. Contents of charge. Every charge under this code shall state the offense with which the accused is charged. If the law which creates charge, create the offense, so on and so forth. Not 211. Contents of charge. 212. Particulars as to time, place, and person.
Yes.
But in this instant case, the framing of the charge, the particulars of the time, place, and person is that the accused has demanded and accepted illegal gratification on a particular date. I'll read 212, my lord. The charge shall contain such particulars so as to the time and place of the alleged offense, and the person, if any, against whom, or the thing, if any, in respect of which it was committed, as are reasonably sufficient to give the accused notice of the matter with which he is charged. Now, if my lord permits, I'll read subsection 1 again.
Yes.
The charge shall contain particulars as to the time and place of the alleged offense, and the person, if any, against whom, or the thing, if any, in respect of which it was committed, as are reasonably sufficient to give the accused notice of the matter with which he is charged. When the accused is charged with criminal breach of trust, so this subsection 2 will not apply. Then 213, when matter of committing offense must be stated. When the nature of the case is such that the particulars mentioned in 211 and 212 do not give the accused sufficient notice of the matter with which he is charged, the charge shall also contain such particulars of the manner in which the alleged offense was committed as will be sufficient for that purpose. Then illustrations are provided, these would not apply to the instant case, but nevertheless, none of the illustrations are not directly on the point in relation to the instant case, but what 213 requires is, if 211 and 212 cannot be fulfilled, then you have to give the reasonable particulars is what 213 says. Then 214. Words in charge taken in sense of law, I will not trouble my lords there. Then effect of error, 215. No error in stating either the offense or the particulars required to be stated in the charge, and no omission to state the offense or those particulars shall be regarded at any stage of the case as material, unless the accused was in fact misled by such error or omission, and it has occasioned a failure of justice. But if I fail in the charge, in the framing of the charge, in any of these 211, 212, 213, 214, ಯಾವುದನ್ನು comply ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ 215 says, if it is there, if a bundle is there, and if that is sufficient to disclose to the accused what he is faced with, then unless he was misled by such error or omission, and unless it has occasioned a failure of justice, the charge, framing of the charge itself will not have any adverse effect on the prosecution, is what 215 says. Then coupled with all this, 464. 464 I'll read. If my lords were to come to conclusion that the charge is defective or that failure of justice has occasioned, then what remains for my lords to see is the effect. 464. No finding, sentence, or order by a court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed, or on the ground of any error, omission, or irregularity in the charge, including any misjoinder of charge, unless in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact been occasioned thereby. If the Court of Appeal confirmation or revision is of the opinion that a failure of justice has in fact been occasioned, it may, in the case of an omission to frame a charge, order that a charge be framed and that the trial be recommenced from the point immediately after the framing of the charge. In the case of an error, omission, or irregularity in the charge, direct a new trial to be had upon a charge framed in whatever manner it thinks fit, provided that if the court is of the opinion that the facts of the case are such that no valid charge could be preferred against the accused in respect of the facts proved, it shall quash the conviction. So, my lord, with a combined reading of these five provisions, 211, 212, 213, and 215, along with 464, my respectful submission, my lord, would be that in relation to the offense under section 7 and 13(1)(d), in relation to which the accused was charged, the ingredients of 13(1)(d), my lord, does not require, my lord, to that an official favor or disfavor is to be stated. Ingredients of section 13(1)(d).
Is it your contention there is an error in the charge?
Lord,
Is it your contention that there is an error in the charge?
Lord, it is not my contention that there is an error in the charge.
So there is no
I am,
error.
Lord, I am trying to, Lord, respond to, Lord, a query from this honorable court that is, since this honorable court has a feeling that there could be some kind of an error or a deficiency in the charge which is put to the accused.
There is not an error, sir. Even it is the specific contention of the prosecution. It is your contention.
Yes.
That the official work was pending.
Lord, yes, Lord. I bow down to that.
Was filed
But
to that.
I bow down to that.
Accordingly, charge was framed,
I bow down to that.
but the oral evidence and the documents are entirely against that.
I bow down to that. But
So it is
still,
not a case of error in the charge.
but in any which way, I was, if your lordship is pointing out not error in the charge sheet, or your lordship is pointing out to error in the charge,
Pointing out the inconsistency stand taken by the prosecution as found in the charge sheet and the charge when compared to the oral and documentary evidence.
but if I may, my lord, with respect, it's not an inconsistency of the prosecution. Prosecution has said the work was pending. But the documents reveal, as my lord rightly put it, my lord, work was completed by them. But my lord, what is the work completion unless it is given to the, my lord, the complainant? Is what comes to my mind. And I would
When
Rest-
the investigating officer came to know that the work was already
complete.
at the time of trap. When the trap mahzar was drawn,
Yes,
it was brought to his notice that the work was already completed. It
in
was
the computer,
never- Yes, computer.
by not by issuing of a certificate.
Not necessary. At least he came to know that in the computer that kata has been changed.
Yes,
So message was sent to your lordship to
One-
his number.
1 minute, 1 minute. Then the contention of the prosecution should have been, even though it is changed long back, about a month back, not 1 day or 2 day earlier, a month back, it was changed. It was never brought to the notice of the complainant.
yes, my lord. I understand.
No such case was made out.
No, it was not. I'm not trying to improve that today.
You cannot, sir.
No, I'm not
Cannot
even,
improve.
I'm not even going there. I'm only saying whatever fault, whatever defect, whatever deficiency my lord would point out or would find, would observe in any of the materials of the prosecution. Fact remains, there is a public servant.
No.
Fact
Yes,
remains that there is a demand and acceptance. Fact remains,
that will have an effect on the defense taken by the accused, that no official work was pending with him and he never demanded any amount from the complainant. That will have an effect.
so your lordship is probably, my lord, sailing with my submission. I mean, not for use of for want of a better term, your lordship would accept my submission that there is, in spite of all these deficiencies, that there is a public servant, there is a demand, there is an acceptance. So your lordship is attaching, not that explanation, not to view from section 20 perspective, presumption. If I were to say that there is section 7, presumption is applicable, demand and acceptance is proved, section 20 presumption is applicable, then your lordship will see whether that explanation and the subsequent conduct, cross-examination questions, will that, not the preponderance of probability, will that not inure to the benefit of the accused. Now, to that, my respectful answer, my respectful submission would be,
Come to section 20.
I'll read. Where in any trial of an offence punishment under section 7 or 11 or clause A, clause B of section 13, it is proved that an accused person has accepted or obtained or has agreed to accept or attempted to obtain for himself or for any other person any gratification other than legal remuneration or any valuable thing from any person, it shall be presumed unless the contrary is proved that he accepted or obtained or agreed to accept or attempted to obtain that gratification or that valuable thing, as the case may be, as a motive or reward, such as is mentioned in section 7, or as the case may be without consideration or for a consideration which he knows to be inadequate, where in any, then section
So
12.
this provision provides presumption for the motive or reward for having accepted the demanded and accepted the amount.
Yes. So for the, yes,
But your oral and documentary evidence reverses this presumption.
Blood, I would still not contend that not, yes, in the computer it is seen that the khata is transferred. Yes, my lord, I agree 100%. The charge sheet column number 7 should have read a little different. One more sentence should have been added in the column number 7. In the charge also, my lord, which is put to the accused, one more sentence should have been added. Yes, my lord, all these are deficiencies. All these are defects or errors. But still, my lord, will my lord look at these column number 7, look at this charge framed without not the recourse to provisions of section 211 to 15 and 464, my lord, my respectful request would be a firm no. For the simple reason, Lord, whatever Lord, mistakes have been committed by the investigating officer, by the prosecutor, by the learned special court in framing charge or putting it to the accused, fact remains, my lord, ingredients of 13(1)(d) are fulfilled. Even if my lords were not to draw presumption, ingredients of section 13(1)(d) are fulfilled. It is not related to any work. It is not related to any official favor.
But unfortunately, that was not your contention.
But bundle of facts are there.
Yes,
It is put to the accused.
facts are entirely different. That is
So,
what
my
I'm
lord,
saying.
then, my lord, in that case, my lord, the conclusion or consequence would be that in relation to some other work, my lord, he can accept demand and accept bribe, my lord. That cannot be, my lord, the object of the provisions and what is running through my lord's mind. My lords, what is running through this honorable court's mind, if I can, my lord, state that.
They say,
Yes.
it is your specific contention.
That in relation to work,
Work
yes.
was pending with the accused. He was required to change the khata in respect of the
Yes.
landed property.
Yes.
For that, he demanded and accepted the illegal gratification. The charge sheet was filed in
Yes.
that fashion. The charge was also framed in the same line. But the oral and documentary evidence shows that the work was already completed about a month back. So no official work was pending. Then why there was demand? Why there was acceptance? That is not explained by the prosecution. ಇಷ್ಟೇ ನಾನು ಕೇಳ್ತಾ ಇರೋದು ಮೊನ್ನೆ.
That is not explained.
Yes.
That is not explained. But
Was it not
again,
necessary when you admit that the work was already done about a month back?
Lord, I would say it is not an admission about work completion. But what the IO would say in the cross-examination is, when he, during the trap Panchanama, when he opened the computer, he saw that the khata has been transferred.
It means to say that the work was complete.
Lord, again, Lord, it is subjective, is my respectful request to consider.
Provided
Yes.
there is an explanation.
It is not.
PW1.
That is not.
By the investigating.
No, that is not there. No, that is not there. But at least it was for the accused to not to say that it was never done. His only explanation is it was thrust into his pocket.
No work was pending and the amount was thrust into my pocket.
Yes.
Whether that can be accepted or not, it is entirely different.
Yes, yes.
The prosecution is to be successful in proving the initial, discharging the initial burden.
But yes, initial burden is not public servant demand acceptance. But which, in my respectful submission, it stands proved because complaint is not proved. Of course, not the complainant would later turn hostile at the time of trap. While speaking about complaint is proved, not exhibit P1. And the shadow witness not categorically says his witness, his testimony stands unchallenged. It's not denied. It's not controverted in the cross-examination. Complaint is not uncontroverted. Complaint exhibit P1. Right hand wash, left hand wash, it remains there. If it is thrust into pocket, there is no, if it was thrust into pocket,
Shadow witness is PW 3.
PW 3. Page 3, my lord, unnumbered para first from top. Fourth line. ಅಲ್ಲಿ ಆರೋಪಿ ಹೇಳಿದ ಹಣ ತಂದಿದಿರುವ್ರಾ ಅಂತ ಕೇಳಿದಾಗ ರೂಪಾಯಿ 500 ಈಗಾಗಲೇ ನೀಡಿರುವೆ, ಇನ್ನುಳಿದ 2500 ತೆಗೆದುಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿ ಹಣವನ್ನು ನೀಡಿದಾಗ ಆರೋಪಿ ಸದರಿ ಹಣವನ್ನು ಎಣಿಸಿಕೊಂಡು ಅವರ ಪ್ಯಾಂಟಿನ ಜೇಬಿನಲ್ಲಿ ಇಟ್ಟುಕೊಂಡ್ರು. If it is thrust into pocket, there is no occasion not for the right hand wash and left hand wash to turn positive.
Yes, what is the reason given by the trial court to acquit?
Not only about pendency of work.
That is the only ground.
That is only.
Now, the other hurdle is interference by the appellate court. When the court can interfere.
Lord, for that, my lord judgment is there. If my lord were to come to conclusion, that there is failure of justice, then your lordship has to probably, my lord, your lordship can.
If two views are possible, two views can be taken, one taken by the trial court and the other view is also possible according to this court. It is not a ground for interference.
No, my lord, I am not even saying that there are two views possible. I am only saying that the trial court looked at it only from a very, very narrow-minded perspective. In the sense, my lord, only 7 ingredients were looked into by the trial court. 13(1)(d), it seems to have been not conveniently or not casually, my lord, ignored. I'm not even speaking about two views, my lord.
Yes, proceed.
Then, Lord, I'll rely on, Lord, this judgment of the Honorable Supreme Court in the case of Camille versus State of Uttar Pradesh.
So according to you, only the offense under 13(1)(d) was made out?
Only, my lord?
Only the offense under 13(1)(d) was made out by the prosecution?
Lord, my respectful submission is both 7 and 13(1)(d) are made out. Lord, your lordships are looking at it from, Lord, yes, khata transfer in the computer was done, but not to the complainant, to the ignorant complainant or not the half knowledge complainant. Lord, as long as he does not look at the certificate in his hand, work is not complete. Whether SMS is there or not, it's not on record here. As long as he does not get the certificate in his hand, work is not complete. Even as on the date of trap, certificate is not issued. Even if it is there in the computer, certificate is not issued, my lord.
Maybe PW1 may be a rustic villager, but
Yes.
not the investigating officer.
Lord, he is not, but still, even for the investigating officer, even as on the later date, but the certificate is not issued. The work was, I will give you the khata certificate, I will get the khata transfer done, but it is not done. But in the records, if it is done, it's not done, not so far as anybody for the, even for me, Lord, I am not a rustic villager. Even for me, unless I see that in my hand, that is what it is. Then, Lord, coming to this, yes.
Yes, proceed.
Lord, this judgment, Camille versus State of Uttar Pradesh, it is in relation to offense under section 302. But
Why-
Lord, here in this judgment, Lord, quite a few judgments of the Honorable Supreme Court on 464 on framing of charge have been, Lord.
ಚಾರ್ಜ್ ಏನ್ ಬರೋದಿಲ್ಲ ಸರ್ ಇಲ್ಲಿ. Effect of omission ಅದೆಲ್ಲ ಬರಲ್ಲ.
Alla, omission alla, Lord.
It was
About
never
cha-
a contention.
About the mistake in the framing of charge.
That was never a contention of the prosecution.
Lord, it's not my contention. If, Lord, I have to answer my learned friend's contention about the facts which are
So
put to the
it
accused.
is your contention, still the work was pending?
But it is pending insofar as not the certificate is not issued.
Who has to explain that?
But that question has not arisen. But
PW
there is no cross examination on that.
The investigating officer
Yes.
during cross-examination in categorical terms admits
Yes.
that the kata was changed long back.
In the computer. Yes. Yes, madam. I agree.
Then was it not the responsibility of the investigating officer, the prosecution, to explain why he is still contending that the work was pending? Whatever you are now saying,
Yes.
the hard copy of the kata transfer
Yes.
was not provided to PW1.
I am only not, that is my legal submission. to
Is
my
it
lord.
a matter of presumption by the?
No, absolutely not. Not absolutely not. See, but the offense itself is, the case of the prosecution is for the purpose of khata transfer, he has demanded accepted bribe amount. For the purpose.
Yes.
ನಾನು ಹಿಂದೆ ಮಾಡಾಗಿದೆ ನನ್ಗೆ ಇವಾಗ ದುಡ್ಡು ಕೊಡಿ ಅಂತ ಹೇಳಿಲ್ಲ, ಮುಂದೆ ಮಾಡ್ಕೊಡ್ತೀನಿ ಇವಾಗ ದುಡ್ಡು ಕೊಡಿ. ದಟ್ಸ್ ನಾಟ್ ದಿ ಬಂಡಲ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್. ದಿ ಬಂಡಲ್
ಮಾಡಿದ್ರು ಕೂಡ ಅದ್ರದ್ದು ಹಾರ್ಡ್ ಕಾಪಿ ನನಗೆ ಕೊಡ್ಲಿಲ್ಲ ಅನ್ನೋದು ನಾಟ್ ಕಂಟೆಂಟ್.
in my no, I am only trying to make an effort at explaining the subjective pendency of work. The demand and acceptance is not in relation to what he has done about 1 month ago or what he is promising to do a little later. The demand and acceptance is in relation to khata transfer. It can be could have been completed by the time that he has demanded. He is not saying nan ಮಾಡ್ಕೊಡ್ತೀನಿ ಮುಂದೆ ನೀನ್ ಇವಾಗ ಕೊಟ್ರೆ ಅಂತ. That's not the case.
What PW13 PW7 says, the sanctioning authority,
He also admits that work is complete.
he is supposed to verify the records before according sanction.
Yes.
What is his evidence?
He also says the same thing, that the work is completed. Second page of PW7, last unnumbered paragraph. ದಿನಾಂಕ 29/9/2012 ಖಾತೆ ಬದಲಾವಣೆ ಆಗಿತ್ತೋ ಇಲ್ಲವೋ ಎಂಬುದನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದ್ದೇನೋ ಇಲ್ಲವೋ ಈಗ ನೆನಪಿಲ್ಲ. ಅಭಿಯೋಜನೆಗೆ ಅನುಮತಿ ಮೊದಲು ಕಡ್ಡಾಯವಾಗಿ ನಾನು ಪೂರ್ವಾಭಿವಾಗಿ ತನಿಖೆ ಮಾಡಬೇಕು ಎಂಬುದು ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಸ್ವಯಂ ನುಡಿಯುತ್ತಾ ದಾಖಲೆಗಳನ್ನು ಪರಾಮರ್ಶಿಸಿ ಮೇಲ್ನೋಟಕ್ಕೆ ಅಭಿಯೋಜನೆಗೆ ಅನುಮತಿಸಲು ಸಾಕಷ್ಟು ದಾಖಲೆಗಳಿವೆ ಎಂಬುದನ್ನು ನೋಡಬೇಕು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. 19/6/2012 ರಂದು, ಅಂದರೆ ಟ್ರ್ಯಾಪ್ ಆಗುವ 100 ದಿವಸಗಳ ಹಿಂದೆಯೇ ಖಾತೆ ಬದಲಾಯಿಸುವ ಕ್ರಮ ಆರಂಭಿಸಲಾಗಿದೆ ಎಂಬುದು ಗೊತ್ತಿಲ್ಲ. ಸದರಿ ಅರ್ಜಿಯು ಸಂಖ್ಯೆ 8903 ಆಗಿತ್ತು ಎಂದು ಟ್ರಾನ್ಸ್ಫರ್ ನಂಬರ್ 34 ಆಗಿತ್ತು ಎಂದರೆ ಗೊತ್ತಿಲ್ಲ. 22/6/2012.
He has not verified anything. Blindly accorded sanction.
Para 15 he himself has said you will also. Para 15.
I'll read further. ದಿನಾಂಕ 25/8/2012 ರಂದು ಖಾತೆ ಬದಲಾಯಿಸುವ ಅನುಮೋದನೆ ಕೂಡ ಆಗಿತ್ತು ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಖಾತೆ ಬದಲಾವಣೆ
ಗೊತ್ತಿಲ್ಲ. He does not deny.
That is that is not at the
He is
time.
the deputy commissioner.
Yes.
He must be knowing the stages of change of kata. He should have verified whether the work was pending or not. If the work of transfer, the change of kata in the computer was already done, he should have stated, yes, it was done, but the copy was not provided to the PW1.
What he is stating here
Because
is,
he is a higher officer.
yes, yes. But he
His
says he
evidence
does not.
should be very specific.
He says he does not remember at this stage
Remember ಅಲ್ಲ,
whether it was done or not earlier.
ಗೊತ್ತಿಲ್ಲ.
First sentence is at page 2, last unnumbered para. First sentence is ದಿನಾಂಕ 29/9/2012 ರಂದು ಖಾತೆ ಬದಲಾವಣೆ ಆಗಿತ್ತೋ ಇಲ್ಲವೋ ಎಂಬುದನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿದ್ದೇನೋ ಇಲ್ಲವೋ ಈಗ ನೆನಪಿಲ್ಲ.
Yes.
ನೆನಪಿಲ್ಲ.
Next sentence.
ಅಭಿಯೋಜನೆಗೆ ಅನುಮತಿಸುವ ಮೊದಲು ಕಡ್ಡಾಯವಾಗಿ ನಾನು ಪೂರ್ವಭಾವಿ ತನಿಖೆ ಮಾಡಬೇಕು ಎಂಬುದು ಸರಿಯಲ್ಲ.
What does it mean?
He has to
Inquiry is to be held, no verification is to be held. According to him, mechanically he has to accord sanction.
No, ಪೂರ್ವಭಾವಿ ತನಿಖೆ means not preliminary investigation. He should not do.
ಅಲ್ಲ, ವೆರಿಫೈ ಮಾಡೋ. ಪೆಂಡಿಂಗ್ ಇತ್ತೋ ಇಲ್ವೋ, ಮುಗಿದಿದೋ ಇಲ್ವೋ, ಪ್ರೈಮಾ ಫೇಸಿ ಮೆಟೀರಿಯಲ್ಸ್ ಇದೆಯೋ ಇಲ್ವೋ, ದಟ್ ಈಸ್ ಹಿಸ್ ಡ್ಯೂಟಿ. He says ಸರಿಯಲ್ಲ.
But records are placed before him, those are not, he has seen the records. But kindly see, not the kind of questions, in the second unnumbered para on page 2. Or rather not, I'll read the entire authorities evidence.
ಅದು ಏನ್ ಬೇಡ ಸರ್, ಅದೆಲ್ಲ ಪ್ರೊಸೀಜರ್ ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳ್ಕೊಂಡು
ಅಷ್ಟೇ.
ಹೋಗಿದ್ದಾರೆ, ಅನ್ನೆಸೆಸರಿ ಅವೆಲ್ಲ.
ಅಷ್ಟೇ.
Yes. Procedure, whatever it may be, the fact remains.
But what the sanctioning authority sees, whether or not investigation papers are in order. Statement,
ಹೇಳೋದು ಸರ್ ನಾನು.
yes, but he need not at the stage of.
PW1 may not be in a position to explain. PW3 may not be in a position to explain. But PW7 and PW8. I am not finding fault with either PW1 or PW3. They are not well versed with these procedures. He says, trap ಗೆ 40 ದಿನ ಮೊದಲೇ ಆರೋಪಿ ಖಾತೆ ಬದಲಾವಣೆ ಕರ್ತ ಭೂಮಿ ಕೇಂದ್ರಕ್ಕೆ ರವಾನೆಯಾಗಿತ್ತು ಎಂಬುದು ಗೊತ್ತಿಲ್ಲ.
Yes. But without confronting anything, not these questions are put. These questions are not part of the investigation records. 40 ದಿನಗಳ ಮುಂಚೆ ಭೂಮಿ ಕೇಂದ್ರಕ್ಕೆ ಹೋಗಿತ್ತು.
But that file was recovered.
File was recovered. Yes.
File is exhibit.
File is I think P4 and P5.
P4, P5.
P4 and 5.
P4 and 5. 5, 6 and J slip, 5, 6 also. J slip will be issued. J slip register.
When this file was with the PW7, the sanctioning authority, was it not his duty to verify it? He should have sought for explanation by the investigating officer. According to this file, the khata is already transferred. Still, why you are saying that the work is still pending? He could have sought for that explanation. ಏನು ಮಾಡಿಲ್ಲ, ಎಲ್ಲ ಮೆಕ್ಯಾನಿಕಲಿ ಹೋದಾಗ ಅನ್ಸೋದಿಲ್ಲ. Say with some purpose this sanction, the
is required.
requirement of according sanction is provided under the act. It is not an empty formality.
But that's not the
It
case
will
of the
achieve
accused.
a laudable object before prosecuting the accused. And he says, ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾನು ನೋಡ್ಬೇಕು ಅನ್ನೋದು ಸರಿಯಲ್ಲ. And so is the evidence of PW8, the investigating officer.
Page 5, Lord, unnumbered last paragraph on page 5.
Here PW7,
8.
PW8, page 5.
Page 5, last unnumbered paragraph.
Yes.
ಫಿರ್ಯಾದಿಗೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಲು ಆರೋಪಿಯನ್ನು ಕೇಳಿದಾಗ ಆತ ಒಂದು ಕಬ್ಬಿಣದ ರ್ಯಾಕ್ ನಿಂದ ಒಂದು ರಿಜಿಸ್ಟರ್ ಅನ್ನು ಹಾಜರುಪಡಿಸಿದ್ರು. ಸದರಿ ರಿಜಿಸ್ಟರ್ ನಿಪಿ 6 ಇದೆ. ನಿಪಿ 6ರ 91ನೇ ಪುಟದಲ್ಲಿ ಫಿರ್ಯಾದಿಗೆ ಸಂಬಂಧಪಟ್ಟ ನಮೂದನೆ CR-695 ಎಂದು ಇದೆ. ಇದು ನಿಪಿ 6A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಿಪಿ 6ಕ್ಕೆ ಪಂಚರು ಮತ್ತು ನಾವು ಸಹಿ ಮಾಡಿದೆವು. ಹಾಜರಾತಿ ಪುಸ್ತಕ ಕುರಿತು ಕೇಳಿದಾಗ ಅಂತಹ ಪುಸ್ತಕ ನಿರ್ವಹಿಸಿರುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿದರು. ನಂತರ ಅಣ್ಣೇಗೌಡ ಎಂಬ ಶಿರಸ್ದಾರ ಹಕ್ಕು ದಾಖಲೆ ವಹಿ ನಮೂನೆ 12, 2011, 12 ಮತ್ತು 12, 13 ಹಾಜರುಪಡಿಸಿದರು. ಅವು ನಿಪಿ 4 ಮತ್ತು 5 ಇವೆ. ಇವುಗಳಿಗೂ ಫಿರ್ಯಾದಿ ಪಂಚರು ಮತ್ತು ನಾವು ಸಹಿ ಮಾಡಿದೆವು. ಆರೋಪಿಗೆ ಈ ಕುರಿತು ಸಮಜಾಯಿಷಿ ಕೇಳಿದಾಗ ಅವರ ಸಮಜಾಯಿಷಿ ನೀಡಿದ್ದಾರೆ. ಅದು ನಿಪಿ 49 ಇದೆ. ಅದಕ್ಕೂ ನಾವು ಸಹಿ ಮಾಡಿದೆವು. ಸಮಜಾಯಿಷಿ ಕುರಿತು ಪಂಚರಿಗೆ ಕೇಳಿದಾಗ ಸಮಜಾಯಿಷಿ ಸರಿಯಾದುದಲ್ಲ ಅಂತ ಹೇಳಿದರು. ಕಾರಣ ತಾವೇ ಖುದ್ದಾಗಿ ನೋಡಿದ್ದೇವೆ ಎಂದು ಹೇಳಿದರು.
ಆಯ್ತು, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಈಗ ಬನ್ನಿ.
Cross examination starts at page
Page
9.
number 9.
Then
Unnumbered
Lord,
para 2.
first paragraph, first page, para 2. ಈ ಪ್ರಕರಣದ ಪ್ರಥಮ ವರ್ತಮಾನದಲ್ಲಿ ದಾಖಲೆ ಮೇಲೆ ನಾನು ತನಿಖೆಯನ್ನು ನಡೆಸಿದ ಸಮಯದಲ್ಲಿ ಗಣಕಯಂತ್ರದಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಫಿರ್ಯಾದರ ಹೆಸರಿಗೆ ಆತನು ಕ್ರಯ ಹೊಂದಿದ ಜಮೀನು ಖಾತೆ ಆತನ ಹೆಸರಿಗೆ ಬದಲಾವಣೆಯಾಗಿತ್ತು. ದಿನಾಂಕ 20
ಆಗಿತ್ತು.
ಎಸ್
Yes.
ದಿನಾಂಕ 28/8/2012 ಫಿರ್ಯಾದಿದಾರರ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆ ಆಗಿತ್ತು. ದೂರು ದಾಖಲಾದ ದಿನಾಂಕ 29/9/2012 ಆಗಿದೆ. ಫಿರ್ಯಾದಿ ದೂರು ಕೊಡುವ ಸಮಯಕ್ಕೆ ಫಿರ್ಯಾದಿಯ ಹೆಸರಿಗೆ ಖಾತೆ ಬದಲಾವಣೆಯಾಗಿದ್ದರೂ ಆತನು ಅನಕ್ಷರಸ್ಥನಾಗಿದ್ದ ಕಾರಣ ಈ ವಿಷಯವನ್ನು ಮರೆಮಾಚಿ ಆರೋಪಿ ಖಾತೆ ಬದಲಾವಣೆಗೆ ಲಂಚದ ಬೇಡಿಕೆ ಇಟ್ಟಿದ್ದನು ಎನ್ನುತ್ತೇನೆ. ದಿನಾಂಕ 21/8/2012
So ಈ explanation ಕೊಟ್ಟಿದ್ದಾನೆ. That explanation should have been in the charge sheet.
ಫಿರ್ಯಾದಿದಾರರ ಜಮೀನಿನ ಬಗ್ಗೆ ಖಾತೆ ಬದಲಾವಣೆಯಾಗಿತ್ತು ಎಂದರೆ ಸುಳ್ಳು. ಆರೋಪಿ ತನ್ನ ಪಾಲಿನ ಕರ್ತವ್ಯವನ್ನು ದಿನಾಂಕ 21/8/2012 ಮುಗಿಸಿದ್ದ ಎಂದರೆ ಸುಳ್ಳು. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಫಿರ್ಯಾದಿ ಖಾತೆ ಬದಲಾವಣೆಗೆ 19/6/2012 ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಅಂದಿನಿಂದ 25/8/2012 ನಡೆದ ಎಲ್ಲಾ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಮಾಹಿತಿಗಳನ್ನು ಫಿರ್ಯಾದಿಯಿಂದ ಮೊಬೈಲ್ ಸಂಖ್ಯೆಗೆ ಬಂದಿದೆ ಎಂದರೆ ಸುಳ್ಳು. ಫಿರ್ಯಾದುದಾರರ ಮೊಬೈಲ್ ನಂಬರ್ ಅನ್ನು ದೂರಿನಲ್ಲಿ ನಮೂದು ಮಾಡಿಲ್ಲ. ದಿನಾಂಕ 29/9/2012 ಈ ಪ್ರಕರಣದ ಪ್ರಥಮ ವರ್ತಮಾನದ ವರದಿ ದಾಖಲಾಗುವ ವೇಳೆಗೆ ಫಿರ್ಯಾದುದಾರರ ಜಮೀನು ಖಾತೆಯು ಆತನ ಹೆಸರಿಗೆ ಬದಲಾವಣೆಯಾಗಿದ್ದು ವಿಚಾರ ನನಗೆ ತಿಳಿದಿದ್ದರೂ ಕೂಡ ಮತ್ತು ಆರೋಪಿ ಈ ಖಾತೆ ಬದಲಾವಣೆಗೆ ಲಂಚ ಬೇಡಿಕೆ ಇಟ್ಟಿಲ್ಲ ಎಂಬ ವಿಚಾರ ತಿಳಿದಿದ್ದರೂ ಸಹ ಆರೋಪಿ ವಿರುದ್ಧ ಸುಳ್ಳು ದೂರನ್ನು ದಾಖಲು ಮಾಡಿಕೊಂಡಿದ್ದೇನೆ ಎನ್ನುವ ಸಲಹೆಗಳು ಸುಳ್ಳು. ಫಿರ್ಯಾದಿಯು ನಿಪಿ so and so.
Whether any of the witnesses have spoken to about the procedure for change of khata?
Himself, PW8 himself has spoken as per the judgment. But I do not see that here, that he has spoken about what the judgment records is that PW8 himself has spoken about the procedure.
According to him, ಎಲ್ಲಿದೆ ನಾನು ಹೇಳಿದ procedure?
Not?
Where is that procedure spoken to by PW?
ಅಲ್ಲ, ಇವ್ರು ಆತರ ಡೀಟೇಲ್ ಆಗಿ ಹೇಳಿಲ್ಲ. ಇವ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮಾತ್ರ ಇವ್ರು ಇಷ್ಟು ಅಡ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇಷ್ಟು ಪ್ರೊಸೀಜರ್ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. I'll just not point out from the judgment, which does not seem to tally with the deposition.
Para 15.
Para 15 of the judgment.
Deputy Commissioner himself has said.
Deputy Commissioner ಹೇಳಿದ.
Yes, PW7, Deputy Commissioner, I have no power to change the khata antane ಹೇಳಿದೆ. Where is the question of page 15, my lord, para 15, my lord.
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ. Para 15 ಅಲ್ಲಿ
following admissions of the judgment.
Para 15 ಅಲ್ಲಿ
It comes in the cross examination, he gives the following admissions. That is
Para
Deputy
15
Commissioner.
ಅಲ್ಲಿ PW8 ಇದನ್ನ ಇಷ್ಟು ಹೇಳಿದ್ದಾರೆ, ಅಡ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ Para 15 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
The
That
revenue
the revenue inspector has no power to change the khata, that the procedure of change of khata has been computerized.
Yes.
That immediately after any immobile property is registered, the
Yes.
Tahsildar officer will receive the information from the sub-registrar's office.
Yes.
That immediately after the receipt of the information to the Bhumi software of the Tahsildar office, the above information will be sent to the concerned revenue inspector and also the village accountant.
Yes.
That in this case, in spite of the registered document in the name of the complainant, the khata has not been changed into his name. He admits that after the registration of the complaint in this case, and while going through the computers, he came to know that the khata of the land in question had been changed into the name of the complainant. He admits that the date of khata change was 28/8/2012 and the date of registration of complaint is 29/8/2012.
This is contrary to item number 5. ಚೇಂಜ್ ಆಗಿಲ್ಲ ಅಂತ DC ಹೇಳಿ, ಆಮೇಲೆ ಚೇಂಜ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
But keeping aside not the pendency of work for a moment, even not the defective, I admit not, if your lordship were to come to conclusion that there is defect, there is deficiency in the charge sheet, in the charge and in the case set out by the prosecution. But fact remains not, the ingredients of 13(1)D are fulfilled.
No. ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಸರ್. The specific contention taken by the prosecution is to be proved.
Blood content, blood, I'll come to that. Blood, if
You
your lordship.
cannot say
Yes.
ಇದೊಂದು ಆಗ್ಲಿಲ್ವಾ ಇದು ಬಿಡಿ ಈ ರೀತಿ
ಅಲ್ಲ, ಆ ತರ ಅಲ್ಲ.
No.
I'm not.
no new case could be made out.
No, absolutely not. That's not my.
Hmm.
Blood, no new case can be made out,
Yes.
but I agree.
Yes.
But no new facts can be set out, not I agree. Facts which are on record, facts which are available to the knowledge of the accused is required to explain. And that is what this judgment, Camille versus State of UP, not after not scanning through all the judgments right from Willie Slaney versus State of Madhya Pradesh 1954. What is charged, how it has to be looked into. My lord, I'll just trouble my lords only with para 14 of this judgment. Para 12, your lordship will see William Slaney versus State of Madhya Pradesh 1954. That is followed para 13. Not William Slaney is not Constitution bench judgment. Para 13, following the Constitution bench in Willie Slaney case, the bench of 3 judges of this court in Gurbachan Singh observed that the court is not to look into technicalities, but to the substance and held as under. That is para 13. I'll again not trouble reading that not. Para 14 only I'll read. Para 14, again it is an extract from earlier judgment. Para 14, after considering the meaning of the expression failure of justice and after referring to the Constitution bench in Willie Slaney and Gurbachan Singh, this court in Mainpal versus State of Haryana held as under. In Shamna Sahib versus State of Karnataka, this court considered the meaning of the expression failure of justice occurring in section 464. This court held thus, a conviction would be valid even if there is any omission or irregularity in the charge, provided it did not occasion a failure of justice. The criminal court, particularly the superior court, should make a close examination to ascertain whether there was really a failure of justice or whether it is only a camouflage. The above principles was reiterated in several decisions, so and so. Para 17 of that judgment. The following principles relating to 212, 215 and 464 of the court relevant to this case become evident from the said enunciations that these 4 guidelines are framed.
Yes.
The object of framing a charge is to enable an accused to have a clear idea of what he is being tried.
ಅವೆಲ್ಲ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ಇವು. Still the investigating officer and the PW7, the sanctioning authority, you maintain that the work was pending. So there cannot be an error in the charge.
Yes, not in so many. Work was pending, not in so many words. The complaint.
So you maintain that there is no there is no error in the charge.
In my
charge is very perfectly all right.
Lord permits me, Lord, I'll stick to that contention. That it is, Lord, the charge is sufficient, Lord, to be put to the accused, is my respectful contention.
If the contention of the prosecution was something else.
Yes.
Suppose the investigating officer in the charge sheet has stated that the accused has already changed the kata in the computer, but has not provided the copy to PW1 and misled him stating that the work is pending.
We would not be laboring so much, yes.
And even thereafter, if the court has framed that charge, you can say there may be error.
Yes.
It cannot inure to the benefit of.
We would not have been laboring so much, Lord. Yes, Lord, what your lordship is saying, Lord, my contention is the charge is appropriate.
Yes.
It is sufficient. That is my contention. Charge is sufficient. Since my lord raised not this question, I am trying to, my lord, answer my lord's question, Lord.
Why I raise that is that even if the prosecution has, even if the charge sheet, in the charge sheet, there is something is left out. While framing the charge, hearing before charge and on the stage, it is for the prosecutor, after going through the records, to apprise the court regarding the framing of the charge. No prosecutor fortunately is not, is doing that. At least that, at that
Lordship meant
stage,
unfortunately.
no one is doing that.
Uh,
ಎಲ್ಲದು ಫಾರ್ಚುನೇಟ್ಲಿನೇ ಇವಾಗ, ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಯಾವುದೂ ಇಲ್ಲ. At least at that stage, prosecutor could have drawn the attention of the court for framing appropriate charge. That is what I said. It is not that the charge is erroneous. No.
Yes, madam. But, ಅದ್ರ ಬಗ್ಗೆ ಅಲ್ಲ, this is not criminal trial.
Sir, ಆ ಸ್ಟೇಜ್ ಯಾಕಿರ್ಬೇಕು ಹೇಳಿ, ಹಿಯರಿಂಗ್ ಬಿಫೋರ್ ಚಾರ್ಜ್ ಅಂತ ಒಂದಿದೆ.
I agree, madam. That's why not this entire gamut of provisions.
ಬರೋದಿಲ್ಲ.
Yes.
Prosecutor should apply his mind, the court should apply its mind, and the advocate for the accused also should apply his mind.
Yes.
ಅದು ಸುಮ್ಮನೆ ಲೆಟರ್ ನಲ್ಲಿ ಇದೆ ಹೊರತು no one is using that.
But I agree. But this is criminal trial now. This, in any criminal trial, there will be 100 mistakes at least.
ಇರುತ್ತೆ.
At least 100 mistakes.
When such mistake go to the root of the matter, ಇದು crop up ಆಗುತ್ತೆ. Otherwise we will
Just to answer that, permit me these last few minutes, couple of minutes, then I'll not trouble any further. This para 17 of this judgment, main pal versus, which is extracted here, para 17. ಅದರಲ್ಲಿ 3 sub paras ಇದೆ, ಅಷ್ಟು ಓದ್ಬಿಡ್ತೀನಿ.
Yes.
The following principles relating to section 212, 215.
ಏನದು framing of the charge, error in the charge.
ಹೌದು. Kindly see, my lord, the second sub para. The accused is entitled to know with certainty and accuracy the exact nature of the charge against him, and unless he has such knowledge, his defense will be prejudiced. Where an accused is charged with having committed offense against one person, but on the evidence led he is convicted for committing offense against another person without any charge being framed, the accused will be prejudiced, resulting in a failure of justice. But there will be no prejudice or failure of justice where there was an error in the charge and the accused was aware of the error. Such knowledge can be inferred from the defense, that is, if the defense of the accused showed that he was defending himself against the real and actual charge and not the erroneous charge. But here in this case, specific questions were, work is completed. So he was aware of the charge. He was aware of the actual charge which is against him, not the erroneous charge. He was not even saying, Lord.
Not the error, sir. That was the defense taken by the accused.
Yes, Lord. That
was the defense
so,
taken by the accused.
yes, Lord. So their lordship say, if he was taking that defense, it means that he was aware of the actual charge, even in spite of an erroneous charge. But kindly bear with me, Lord, on this. It runs from, but there will be no prejudice or failure of justice in that second subpara. Then the third subpara, Lord, in judging a question of prejudice as of guilt, the courts must act with a broad vision and look into the substance and not to the technicalities, and their main concern should be to see whether the accused had a fair trial, whether he knew what he was being tried for, and whether the main facts sought to be established against him were explained to him fairly and clearly, and whether he was given a full and fair chance at defending himself.
Yes. Yes, what do you say?
Only same, Lord. I will reiterate only two points, my Lord. As on the date of draft, your Lordship, it is an admitted fact by the Deputy Commissioner himself. Though there is a contrary statement made by him while deposing, he says that he doesn't know, he has not seen the record. He says that, my Lord, in the para 5, my Lord, he has admitted that I have no power to change the kata. The only thing is, after the registration of the document, the record will be received by the Tahsildar and it will be forwarded to me. After forwarding, my Lord, I will make a note and I will send it to the Tahsildar finished. My job is over.
Who says that?
The Deputy Commissioner, my Lord, may kindly see page 15 of the in his admission, categorical admissions made, para 15, my lord. That the revenue inspector has no power to change the kata. I only put up the record. Records were put up and same was sent to the Tahsildar, and Tahsildar has changed the kata and sent a message through Bhumi Kendra. That is the system from 2003. It is for them to look into the computer and take the copy of that. Previously, what it was happened, your lordship, we used to give a handwritten application for change of kata, and then the Tahsildar, after the change of kata, the revenue inspector or the Tahsildar or the village accountant used to hand over change of kata to us. Here, after computerization, all systems have been abolished, and I am sitting here, my lord. I can take my document, my lord, in Mandya district or Mysore district, anywhere, wherever I have a property. That revenue inspector has no power to change the kata, that the procedure of change of kata has been computerized. That is the second admission. That immediately after an immovable property is registered, the Tahsildar office will receive the information from the sub-registrar's office. I will not receive any information. Then immediately after the receipt of the information to the Bhumi software of the Tahsildar office, the above information will be sent to the concerned revenue inspector and also to the village accountant. Then, my lord, that in this case, in spite of the register, this statement, my lord, is incorrect statement. If it comes to item number 7, that in this case, in spite of the registered document in the name of complaint, the kata has not been changed into his name. This is a wrong admission made. Next, my lord, may kindly see, he admits that after now I will take your lordship's attention with that of item number 7, your lordship. I will skip item number 6 admission, my lord. He says that kata has not been changed. Here he says, he admits that the date of change of kata, the date of kata change was on the day that the date of kata change was 28/8/2012, and the date of registration of the complaint is dated 29/9/2022. He admits that there is a change of kata in 28/8/2012 itself. He admits that after the registration of the complaint in this case, while going through the computers, he came to know that the kata of the land in question had been changed to the name of the complainant. Once the kata has been changed, same was intimated, and it is the duty of a party, my lord, either myself or anybody for that matter, to take the copy through the computer. Question of sending or serving a change of kata in favor of any applicant after the computerization of all the documents, my lord, is not in vogue. That has been taken away in 2003 itself, after the computerization through Bhumi Kendra. That is the system adopted. Therefore, I am not the signatoring authority to change the kata. I only forward. Yes, this document I have verified, I am sending it back, finished. My job is over. Then, my lord, your lordship may kindly come to the para 16, my lord, in the same para 16 of the judgment, last 2 lines. Therefore, there is absolutely no evidence of demand by the accused. That is what stated by PW6.
Yes.
PW6. Next, your lordship may kindly see
Which
only.
PW6?
My lord, PW6, my lord. But PW6, my lord, is one Madhu, my lord.
Who is
Cousin of complainant who is turned hostile.
Complaint cousin himself, my lord. Next, my lord, may kindly come to para page 50, page 22 of the judgment, your lordship. I have gone through the above decisions. My lord would get it, my lord. Page 22. I have gone through the above decision. The Honorable Supreme Court of India has clearly stated that the demand and acceptance of bribe must be proved, and mere proof of recovery of bribe amount will not help the case of the prosecution. The second decision says that unless demand is proved, the presumption under section 20 cannot be raised. In the present case, the demand is not at all proved by the prosecution. PW1 and 6 are the persons who are to depose about the demand, but both of them have turned hostile. The demand is not proved. Therefore, the above decisions squarely apply to the facts of the present case. Next, my lord, may kindly para 17. The evidence of other witnesses are all consequential in nature The admissions given by PW2 and clearly 3 clearly indicate that the accused has no power to change the kata. It is an admitted fact by the Deputy Commissioner himself. Therefore, I was made a scapegoat because in connection with other case, I went to the Assistant Commissioner in respect of this complainant issue for the purpose of evicting from him in an unauthorized encroachment of the road. Taking revenge in respect of that property issue, they have made this allegation. And the division bench, my lord, was in its entirety set aside the dismissal order. And while passing the order, this is what observed, my lord, may kindly see division bench order. Para 24. While dismissing the order, the dismissal, my lord, was challenged before the KIT. KIT, my lord, dismissal order was turned as a modified as a compulsory retirement. This honorable court set aside the entire order, your lordship. ಅಲ್ಲ ಅದರಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಮಾಡಿದಾರೆ ಇದನ್ನ ಈ ಪ್ರಾವಿಷನ್ ಅಕ್ವಿಟಲ್ ಆನರಬಲ್ ಅಕ್ವಿಟಲ್ ಬಗ್ಗೆ ಮಾತಾಡಿದ್ದಾರೆ. Yes.
Acquittal is on that.
And understood. Great. And government has also, my lord, has passed an order, my lord, directing to settle all the benefits, my lord, because he has retired, and no appeal could be filed. It is not a fit case to file appeal. He was not in service throughout, my lord, after the.
Yes.
Not my judgment not that I have produced in the earlier last date not. Constitution bench judgment in Sita Soren's case. I'll take not only to the relevant portion about pendency of work, not whether the work itself is relevant for the offense of bribery.
Definitely not.
But if that is
When
not,
it is the contention of the prosecution that it was the motive for demanding,
yes,
it assumes importance.
but not for the final decision. How it has been treated, not for a moment, page 137 onwards.
One, Delhi, the Sita Soren, page number.
But it starts at page 57. The relevant portion, only 4 paragraphs I'll read, starts with page 137.
Page number?
Page 137. Not under the heading, delivery of results is irrelevant to the offense of bribery. The lordships have considered section 7. And Lord, partly Lord disagreed with the judgment of P.V. Narasimha, 5-judge bench. Lord, at considering section 7, Lord, at para 122 on page 139. Under section 7 of the PC Act, the mere obtaining, accepting or attempting to obtain an undue advantage with the intention of to act or forbear from acting in a certain way sufficient to complete the offense, it is not necessary that the act for which the bribe is given be actually performed. The first explanation to the provision further strengthens such an interpretation when it expressly states that the obtaining, accepting or attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by a public servant has not been improper. Therefore, the offense of a public servant being bribed is pegged to receiving or agreeing to receive the undue advantage and not the actual performance of the act for which the undue advantage is obtained. It is straight law that illustrations appended to a section are of value and relevance and so on. So I'll skip that paragraph. Para 124, section 7 is extracted. Even prior to amendment to PC Act in 2017, section 7 expressly delinked the offense of bribery from the actual performance of the act for which the undue advantage is received. The provision reads as follows, which is the same provision which I read now. Para 125. The unamended text of section 7 of the PC Act also indicates that the act of accepting, obtaining, agreeing to accept or agreeing to obtain illegal gratification is a sufficient condition. The act for which the bribery is given bribe is given does not need to be actually performed. This was further clarified by explanation D to the provision. In explaining the phrase a motive or reward for doing, it was made clear that the person receiving the gratification does not need to intend to or be in a position to do or not do the act or omission for which the motive or reward is received. That's all.
Appeal is dismissed. Dismissed. Appeal is dismissed.
Great. Oblige.
First video.
Serial number 44, G. Manivannan, Jagdish BN.
PF respond in this case.
Hmm.
But finally, I think they seems to have settled, come to some compromise terms. The only issue.
Compromise settle ಆಗ್ತದೆ.
ಇನ್ನು ಆಗ್ತಾ ಇದೆ.
ಇಲ್ಲ.
ಆಗಿದೆ.
ಅಂತರ ಇತ್ತು ಹೇಳ್ಕೊಟ್ಟು ಮಾತಾಡಿ.
ಆಗಿದೆ.
They have come to terms. Ultimately, my lord, the original OS decree has to be set aside. But that is the OS decree which is obtained by fraud. It's
After
sought for some
vacation,
more
any
time.
day.
Finally, then they recognize that they committed.
And responded. Submit in unison that the parties have came to a settlement, came to terms. And the settlement will be reported within 2 weeks. This stamp,
Interim order, madam. Interim order.
interim order will be there.
Second week.
Yes,
Second week of January.
huh?
Second week of January.
Yes, no, second, third week could.
Yes, ma'am.
Next,
Great.
In both cases, interim order is there, madam.
yes.
Much.
Serial number 45.
45,
45, Popat Prashant, Mahesh's.
Settlement has not happened. I'm ready to address on
Yes.
merits, madam. Request for passover, madam. Senior held up in Antapur.
Passover ಆಗೋದಿಲ್ಲ sir.
Is
ಕೊಡಿ.
Date could be fixed, we'll submit a.
ಅದು ಡೇಟ್ ಇವತ್ತಿಗೆ ಕೊಟ್ಟಿದ್ದಲ್ಲ.
synopsis also ready. My request for short passover. Senior is on his legs in Antapur, madam.
The date can be fixed, Your Lordship. We'll make, submit a written synopsis in that.
You please go through the order sheet first.
Last time your lordship said if the settlement, you should have.
What do you read?
I'm aware, Your Lordship. Senior's taken.
Still you are saying.
No, Lordship. Senior's
Even
taken in,
after,
Lordship. I've informed the other side. Senior, I'll inform learner senior as well. Your Lordship. Seek his indulgence as well. Seek
Yes.
short accommodation.
ನಾಳೆಗೆ ಫೈನಲ್
ನಾಳೆ ಆಗಲ್ಲ.
ನಾಡುತ್ತೆ.
Learned counsel for the petitioner submits that.
ಅಲ್ಲ ಎರಡೂ ಇದೆ petitioners respondents
One
ಎರಡೂ
minute.
ಇದೆ ಮತ್ತೆ.
There is no chance of settlement.
I don't think so, the way it is going. So we will submit. In fact, we have made the synopsis also. My colleague has made.
No,
Last
is-
time your lordship was pleased with that.
Your colleague stated there is no chance of settlement.
That's what I'm, just I will ask him also. I don't think so. It is ಇದುವರೆಗೂ ಆಗಿಲ್ಲ. ಇದೆ ಸುಮಾರು ಒಂದು ವರ್ಷದ
And
ಹೇಳ್ಕೊಂಡು.
what is your submission?
But I don't think so, my lord, there is any settlement.
That is what I am recording.
Any settlement.
Counsel for the
Ask-
petitioner submits that there is no chance of settlement. And therefore, he is ready to address the arguments on merits. Then counsel for the respondent raised the short accommodation to address the arguments on merits. The order sheet dated so and so reads as under. In spite of that, the counsel for the respondent is seeking time to afford one more opportunity this time. Next, authorization.
Very well.
Serial number 46.
ಅದರಲ್ಲಿ, what I'm sorry, sorry. ಅದರಲ್ಲಿ ಒಂದು ಮ್ಯಾಟರ್ ಒಂದು ರಿಕಾಲಿಂಗ್ ಬಂದಿದೆ. ಅದರಲ್ಲಿ ಒಂದು ರಿಕಾಲಿಂಗ್ ಇತ್ತು. It was dismissed for non-prosecution for not attending to the office objections. ಅಯ್ಯ ನಂಬರ್ ಏನದು?
11818.
11818.
Hmm.
That may
How
be-
many office objections are there?
3 office objections.
3 ಇತ್ತಂತೆ. We will attend to that.
ಮಾಡಿ first, ನೋಡೋಣ.
Very well.
45.5 ಹಾಗೆ ಇರಲಿ. 45.5 ಹಾಗೆ ಇರಲಿ. Yes, next.
Passport. 46, VK Narendra Babu, Vishwanath
Appellant.
MP.
Appellant in this matter, please. Ready.
Yes,
Please, ma'am.
who is for the respondent?
Respondent Vishwanath MP.
Hmm? First one.
The respondent herein.
1 minute, sir.
Yes.
Who is for the respondent? Could you order sheet? Could you? You moved the memo.
Yes, madam.
You moved the memo.
Yes. ma'am. It was posted before court in the month of July. It was posted.
Hello.
Thereafter, IA ಇದುಗಳು ಇತ್ತು ಅವಾಗೆಲ್ಲ ಬಂದಿತ್ತು.
ಮೂಡ್ ಅಂತ ಇದೆಯಲ್ಲ ಯಾರು ಹೂ ಮೂಡ್ ದ ಮೆಮೊ ಇವರೇ ಮೂಡ್. After vacation. ಅವ್ರು ಬರ್ಲಿ.
ನಾಳೆ ಅಥವಾ ನಾಳೆ ಟ್ರೈ ಮಾಡಿ. Day after tomorrow.
2 days working ಇದೆ ಆಗಲ್ಲ. Counsel for the appellant is present. He moved the memo. For listing. Counsel for the respondent is absent, no representation. Hence list on. Next date of hearing, I'll take up.
Please, madam. It may be posted along with criminal appeal 149.
Other Leonard counsel for the appellant submits that criminal appeal number so and so is connected with the present appeal. Hence, office is directed to list both these appeals together.
For admission, serial number 47, Gopal Krishnamurthy, Syed Riyaz Ahmad.
My lord, appearing on behalf of the respondent, my lord, we have just got instructions from him last night. We seek this honorable court's leave to file wakalat on his behalf, my lord. The previous
memo.
counsel has retired, my lord.
File a memo.
Please, my lord.
File a memo.
Please, my lord.
ಹಾಕ್ಬೇಕು ನಾನು ತಗೊಳ್ತೀನಿ.
Please, my lord.
So ಹೆಸರು ತಗೊಳ್ಳಿ. File a memo. Memo of appearance undertaking to file wakalat on behalf of the respondent. Office is directed to show his name in the cause list. ಅದಾದ್ಮೇಲೆ and the counsel for the appellant is absent, no representation. List down. ಅವರು ಇಲ್ಲ ಇವ್ರು ವಕಾಲತ್ ಹಾಕ್ಬೇಕು ಅದೆಲ್ಲ ಇದೆ. Yes.
These three. Non-compliance of office objection for first time, serial number 1, Nagendra Ji.
Counsel for the petitioner is absent, no representation, list down.
Serial number 2, S. Rashekar.
Petition. Matter may be passed to our lords. I'll comply during the course of it. I'm filing.
There are 9 objections.
I'll comply.
Comply ಮಾಡಿ.
I'll filing the interim bail application, my lord. So
ಇಲ್ಲ ಅದೆಲ್ಲ ಬರಲ್ಲ. Comply with the office objections, short date ಕೊಡ್ತಾರೆ ಮಾಡಿ.
ಅಲ್ಲ, today itself, my lord, I'll comply.
Huh?
Today itself, I'll comply. Matter may be passed. I'll legally
You have to comply with that, sir. Let you comply with that. In the meantime, the learned SCGP will take notice.
Since the matter is
ಎಲ್ಲದನ್ನು ಇವತ್ತೇ ಆಗಿ ಇವತ್ತೇ ಬೇಲ್ ಕೊಟ್ಟು ನಿಮ್ಮನ್ನು ಕಳ್ಸಲ್ಲ ನಾ.
ಅಲ್ಲ, matter is entrusted to CID, the matter ಇದು FPP ಅಲ್ಲಿ ಆಫೀಸ್ ಕಾಪಿ ತಗೊಂಡಿಲ್ಲ, ಫೈಲ್ ಮಾಡಬೇಕು.
Comply with that. Counsel for the petitioner undertakes to comply with objections during the course of the day. If office objections are complied, learned SCGP is directed to take notice by respondent. Issue notice again. Next.
Serial number 3, L. Sudarshan.
Absent, no representation, list down.
Orders first time matter, serial number 4 and 5.
Issue notice, learned SCGP takes notice for respondent. Issue.
Serial number 5.
Yes.
Filed an application not seeking interim bail for the reason the co-accused not approached this honorable court by 438 as well as not also filed 482 not petition under section 482. Interim order was granted in his favor. Not subsequently, he withdrew the petition, the co-accused, not me. Now, my lord, in the 482 petition, he has been asked not to approve this honorable court and seek not anticipatory bail. That's how, my lord, I am also before this honorable court. I was not before this honorable court
You
earlier.
have not invoked 482.
I had no, I had not moved. It's so since my lord co-accused had done it, no, my lord, I am also here. Not the initially, not departmental inquiry, my lord, was not commenced. Not your lordship will
When
find.
the FIR was
61.
registered. When the FIR was registered.
13/4/24. Your lordship will find. Not page number 15.
For 9 months, nothing has happened.
Not why. Not why
Within a week,
because.
nothing will go.
Not why because of this reason. Not at page 61.
What are the offense?
Not offenses alleged. Not are 409 and 420. Not at page 61.
Trial court has rejected your prayer.
Trial court not was pleased to reject.
Noted. Yaru respondent yaru.
Response state.
State, take notice. Get ready to address the argument on the next date. HCGP to take notice for respondent. This term.
Friday.
Friday.
Please.
Right.
Bless.
Serial number 6, Bal Gangadhar Reddy.
Today only I have received the NOC along with the entire charge sheet. Kindly, I'll file it in the counter. Only after vacation. Today only I have received the entire charge sheet.
Counsel for the petitioner, praise for time.
And one more submission, my lord.
Yes.
One more submission, my lord.
Next.
Earlier, there was a direction from coordinate bench that after eyewitness it should be placed.
ಆಯ್ತು ನೀವು ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ನೋಡೋಣ.
Please.
Next.
Serial number 7, SG Rajendra Reddy.
439 petition. 202.
Yes.
My lord, earlier, my lord, this petitioner approached this court, my lord.
Petitioner is sole accused.
Accused number 2.
Accused number 2. In all, how many accused?
My lord, initially, my lord, 11 persons were complained against 11 persons.
FIR.
Now, charge sheet, my lord, only against 2 persons. A1 and A2, husband and wife. Wife is in custody till now. Both of them are. My lord,
Wife is accused number 1 now.
yes, my lord.
What are the offense?
302. 114, 120B, 34.
When he was arrested?
Arrested on 7/7/23. 1 year, 6 months in custody.
Now what is the stage?
Not at, my lord, charges not at framed.
Charge.
Not at framed.
Is it the successive petition?
Yes, my lord.
Only the earlier petition?
Earlier, my lord,
Earlier order?
was dismissed, my lord, withdrawn, not on
Withdrawn.
rates,
Not on merit.
not on rates.
Accused number 1 has not approached?
No, my lord. She is in custody, jail.
Yes. Tell me.
My lord, complaint, my lord, at page 14.
No, charge sheet ಗೆ ಬನ್ನಿ. ಆಮೇಲೆ
Yes,
ಮಾತಾಡಿ.
charge sheet, my lord, at page column number 17. At page 42.
Yes.
ಕಡೂರು ತಾಲೂಕು ಸಕಾಯಪಟ್ಟಣ ವ್ಯಾಪ್ತಿಯ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದ ಸಾಕ್ಷಿ 1ರ ಮಗಳು 19 ವರ್ಷದ ಪ್ರಾಯದ ಭಾರತಿ ಎಂಬಾಕಿ 20/12/70 ಮನೆಯಿಂದ ಕಾಣೆಯಾಗಿದ್ದ ಬಗ್ಗೆ ಸಾಕ್ಷಿ 1ರವರು 21/12/22 ಸಕಾಯಪಟ್ಟಣ ಠಾಣೆ.
Who is the complainant?
Complainant is the mother of the deceased.
Missing complaint.
Missing complaints filed first Melon on 21/12/22.
Then
ಸದರಿ ಕೇಸಿನ ತನಿಖೆಯಲ್ಲಿ ಕಾಣೆಯಾಗಿದ್ದ ಭಾರತೀಯನ್ನು 2/1/23 ಪತ್ತೆ ಮಾಡಿಕೊಂಡು ಬಂದು ವಿಚಾರಿಸಿದಾಗ ಈಕೆಯು ಅದೇ ಗ್ರಾಮದ ವಾಸಿ, ಈಗಾಗಲೇ 17 ವರ್ಷದ ಹಿಂದೆ ಕಾಂತಮ್ಮ ಶೀಸ್ A1 ಕಾಂತ ಎಂಬುವರನ್ನು ಮದುವೆಯಾಗಿದ್ದು 2 ಮಕ್ಕಳಾಗಿರುವ ಕಲಂ 12 ಕಂಡ ಆರೋಪಿ ಮಂಜುನಾಥ ಎಂಬುವನನ್ನು ಪ್ರೀತಿಸಿ ಮನೆ ಬಿಟ್ಟು ಹೋಗಿರುತ್ತೇನೆಂದು ಹೇಳಿಕೆ ನುಡಿದ ಮೇರೆಗೆ ಮನುಷ್ಯ ಕಾಣೆ ಕೇಸು ಮುಕ್ತಾಯಗೊಳಿಸಿ ಭಾರತಿಗೆ ಬುದ್ಧಿ ಹೇಳಿ ಅವರ ತಂದೆ ಮನೆ
deceased.
ಭಾರತೀಯ
Bharati. Deceased.
Yes.
Missing after registration of missing complaint, she was traced.
She was traced and sent back home. And again, my lord, she
And
went,
what was her statement?
she says she was loving, my lord, this petitioner. She was in love with the petitioner. And therefore, my lord, she went with him. Again, my lord, she escaped from the house, my lord, and joined this petitioner.
Yes.
ಅಂದಿನಿಂದ ಸುಮಾರು 1.5 ತಿಂಗಳು ಬಿಟ್ಟು ಫೆಬ್ರವರಿ ಮಾಹೆಯಲ್ಲಿ ಭಾರತೀಯು ಪುನಃ ಮನೆ ಬಿಟ್ಟು ಹೋಗಿ ಆರೋಪಿ ಮಂಜುನಾಥನು ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದ ಎಸ್ಟೇಟ್ಗೆ ಹೋಗಿ ಮಂಜುನಾಥನಿಗೆ ಒತ್ತಾಯ ಮಾಡಿ ಎಸ್ಟೇಟ್ನಲ್ಲಿದ್ದ ಯಾವುದೋ ದೇವಸ್ಥಾನದ ಮುಂದೆ ತಾಳಿ ಕಟ್ಟಿಸಿಕೊಂಡು 2ನೇ ಹೆಂಡತಿಯಾಗಿ ಸಂಸಾರ ಮಾಡಿಕೊಂಡಿರುತ್ತಾಳೆ. ಈ ವಿಚಾರ ತಿಳಿದ 1ನೇ ಆರೋಪಿ ಕಾಂತ ಈಕೆಯು ತನ್ನ ಗಂಡನಿದ್ದ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಇಬ್ಬರೊಂದಿಗೂ ಜಗಳವಾಡಿ ಭಾರತೀಯನು ತನ್ನ ಗಂಡನ 2ನೇ ಹೆಂಡತಿಯಾಗಿ ಸ್ವೀಕರಿಸಿಕೊಂಡು ಇಬ್ಬರು ಒಟ್ಟಿಗೆ ವಾಸವಿದ್ದ ಅವಧಿಯಲ್ಲಿ ತನ್ನ ಗಂಡ ಮಂಜುನಾಥನು ತನ್ನನ್ನು ಕಡೆಗಾಣಿಸುತ್ತಿದ್ದಾನೆ ಎಂದು ಅಸಮಾಧಾನಗೊಂಡು ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ಭಾರತೀಯೊಂದಿಗೆ ಹಾಗೂ ಮಂಜುನಾಥನೊಂದಿಗೆ ಪ್ರತಿನಿತ್ಯ ಜಗಳವಾಡಿರುತ್ತಾಳೆ. ಫಸ್ಟ್ ಟೈಪ್. ಹೀಗಿರುವಾಗ ಪ್ರತಿನಿತ್ಯ ಜಗಳದಿಂದ ಬೇಸತ್ತು ಮಂಜುನಾಥನು ಕಳೆದ ಯುಗಾದಿ ಹಬ್ಬದ ದಿನದಂದು ಭಾರತೀಯ ಮನೆಯವರನ್ನು ತನ್ನ ಮನೆಗೆ ಕರೆಸಿಕೊಂಡು ಪಂಚಾಯಿತಿ ಮಾಡಿದ ಸಮಯದಲ್ಲಿ ಮಂಜುನಾಥ ಹಾಗೂ ಕಾಂತಾರಗಳು ಭಾರತೀಯನ್ನು ವಾಪಸ್ಸು ಕರೆದುಕೊಂಡು ಹೋಗುವಂತೆ ಕೋರಿಕೊಂಡಾಗ ಭಾರತೀಯ ತಂದೆ ತಾಯಿ ಸಾಕ್ಷಿ ಒಂದರುಗಳು ಭಾರತೀಯ ಈಗಾಗಲೇ ತಾಳಿ ಕಟ್ಟಿಕೊಂಡು ಮದುವೆಯಾಗಿದ್ದರಿಂದ ವಾಪಸ್ಸು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸಿದಾಗ ಕಾಂತಾಳು ಭಾರತೀಯ ಜೀವಕ್ಕೆ ಏನಾದರೂ ಆದರೆ ನಮ್ಮ ಜವಾಬ್ದಾರಿ ಇರುವುದಿಲ್ಲ ಎಂದು ಪರೋಕ್ಷವಾಗಿ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾಳೆ. ನಂತರ ಮಂಜುನಾಥನು ಇಬ್ಬರು ಹೆಂಡತಿಯನ್ನು ಕರೆದುಕೊಂಡು ಎಸ್ಟೇಟ್ಗೆ ಹೋಗಿ 6/7/23 ಸಗಣಿ ಬಸವನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಅಂತರಘಟ್ಟಮ್ಮ ನೂತನ ದೇವಸ್ಥಾನದ 48 ದಿನದ ಕಾರ್ಯಕ್ರಮ ಇದ್ದುದರಿಂದ 3 ದಿನ ಮುಂಚಿತವಾಗಿ ಮಂಜುನಾಥನು ಇಬ್ಬರು ಹೆಂಡತಿಯರನ್ನು ಕರೆದುಕೊಂಡು ಊರಿಗೆ ಬಂದು ಹಬ್ಬ ಮಾಡಲೆಂದು ಬಂದಿದ್ದನು. ಹಬ್ಬದ ದಿನದಂದು 1ನೇ ಆರೋಪಿಯ ತಂಗಿ ಮತ್ತು 2ನೇ ಆರೋಪಿಯ ನಾದನಿಯಾಗಿರುವ ಸಾಕ್ಷಿ 14 ಆಹ್ವಾನದ ಮೇರೆಗೆ ತವರು ಮನೆಯ ಸಂಬಂಧಿಕಗಳಾದ ಸಾಕ್ಷಿ 17, 18, 19, 20 ಸಾಕ್ಷಿ 14 ಮನೆಗೆ ಹಬ್ಬಕ್ಕೆಂದು ಬಂದಿದ್ದ ಅವಧಿಯಲ್ಲಿ ಹಬ್ಬದ ಊಟಕ್ಕೆ ರಾತ್ರಿ ಅವರ ಮನೆಗೆ ಬರುವಂತ ಆಹ್ವಾನ ನೀಡಿಸುವ ಸಲುವಾಗಿ ಆರೋಪಿತಳಾದ ಕಾಂತ ಹಾಗೂ ಮಂಜುನಾಥರುಗಳು ಸಂಜೆ 5:30 ಗಂಟೆಯಲ್ಲಿ ಸಾಕ್ಷಿ 16 ಮನೆಗೆ ಹೋಗಿ ಸಾಕ್ಷಿ 17, 18, 19, 20 ಕರೆದಾಗ ಸದೆಯವರುಗಳು ಮರ್ಯಾದೆ ಇಲ್ಲದವರ ಮನೆಗೆ ಊಟಕ್ಕೆ ಬರುವುದಿಲ್ಲವೆಂದು ಆರೋಪಿಗಳಿಗೆ ಬೈದು ನಿರಾಕರಿಸಿ ಕಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಆರೋಪಿಗಳು ವಾಪಸ್ಸು ಮನೆಗೆ ಬಂದು 1ನೇ ಆರೋಪಿಯು ರಾತ್ರಿ ಊಟಕ್ಕಾಗಿ ಅಡುಗೆ ಮಾಡಿದ ನಂತರ ಆರೋಪಿಗಳು ಹಾಗೂ ಭಾರತೀಯು ಸಂಜೆ 7:30 ಗಂಟೆಗೆ ಒಟ್ಟಿಗೆ ಮನೆಯಲ್ಲಿ ಕುಳಿತು ಊಟ ಮಾಡಿದ ನಂತರ ರಾತ್ರಿ 8:30 ಗಂಟೆಗೆ ಭಾರತೀಯ ಆರೋಪಿಯ ಮನೆ ಹಿಂಭಾಗದಲ್ಲಿ ಶೌಚಾಲಯಕ್ಕೆ ಹೋಗಲೆಂದು ನೀರು ತೆಗೆದುಕೊಂಡು ಹೋದಾಗ ಮೇಲ್ಕಂಡ 1 ಮತ್ತು ಆರೋಪಿಗಳು ಭಾರತೀಯು ನಮ್ಮ ಮನೆಗೆ ಬಂದಾಗನಿಂದ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ನೆಮ್ಮದಿ ಇಲ್ಲದೆ ನಮ್ಮ ಸಂಬಂಧಿಗಳು ಸಹ ನಮ್ಮಿಂದ ದೂರ ಆಗುತ್ತಾರೆ. ಈಕೆಯನ್ನು ಇನ್ನೂ ನಮ್ಮನ್ನು ಇಟ್ಟುಕೊಂಡರೆ ನಮ್ಮ ಮರ್ಯಾದೆ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಈಕೆಯನ್ನು ಕೊಲೆ ಮಾಡಿ ಮುಗಿಸಿ ನಿನ್ನೆ ರಾತ್ರಿ ಏನೋ ಆಗಿ ಸತ್ತೋಗಿದ್ದಾಳೆ ಎಂದು ಊರಿನಲ್ಲಿ ತಿಳಿಸೋಣವೆಂದು ಇಬ್ಬರು ಅಪರಾಧಿಕ ಒಳಸಂಚು ನಡೆಸಿ ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಮಾತನಾಡಿಕೊಂಡು 2ನೇ ಆರೋಪಿಯು ಅಪರಾಧಿಕ ದೃಷ್ಟಿಯಿಂದ 1ನೇ ಆರೋಪಿಗೆ ನೀನು ಆಕೆಯ ಶೌಚಾಲಯದಿಂದ ಹೊರಗೆ ಬರುವುದನ್ನು ಕಾದು ಹೊರಗೆ ಬರುತ್ತಿದ್ದಂತೆ ಆಕೆಯನ್ನು ನೆಲದ ಮೇಲೆ ಕತ್ತು ಬೀಳಿಸಿ ಸಾಯಿಸು, ನಾನು ಯಾರು ಬರದೆ ನೋಡಿಕೊಳ್ಳುತ್ತೇನೆಂದು ಹೇಳಿ ಕತ್ತಲೆ ಇದ್ದುದರಿಂದ ನನ್ನ ಮೊಬೈಲ್ ಟಾರ್ಚನ್ನು ಆನ್ ಮಾಡಿ ಆಕೆ ಕೊಟ್ಟು ಕಳಿಸಿ ತಾನು ಹೊರಗೆ ನಿಂತುಕೊಂಡು ಸಮಯದಲ್ಲಿ ಕಾಂತಾಳು ಸಗಣಿ ಬಸವನ ಗ್ರಾಮದ ತನ್ನ ವಾಸದ ಮನೆ ಹಿಂಭಾಗದಲ್ಲಿರುವ ಶೌಚಾಲಯದ ಬಾಗಿಲ ಹಿಂದೆ ನಿಂತುಕೊಂಡು ಭಾರತೀಯ ಬರುವುದಕ್ಕಾಗಿ ಕಾಯುತ್ತಿರುವಾಗ ಭಾರತೀಯು ಶೌಚಾಲಯದಿಂದ ಹೊರಗೆ ಬಂದು ಕೂಡಲೇ ಆರೋಪಿ ಕಾಂತಾಳು ಭಾರತೀಯ ತಲೆ ಕೂದಲು ಹಿಡಿದು ಮನೆಯ ಹಿಂದೆ ಇರುವ ಹೊಲದಲ್ಲಿ ನೆಲದ ಮೇಲೆ ಮಕಾಡಿಯಾಗಿ ಬೀಳಿಸಿಕೊಂಡು ಆಕೆಯನ್ನು ಕೊಲೆ ಮಾಡಿದ ಉದ್ದೇಶದಿಂದ ಕೈಗಳಿಂದ ಕುತ್ತಿಗೆ ನೀಸಿಗಿ ಉಸಿರುಗೆಟ್ಟಿ ಕೊಲೆ ಮಾಡಿ ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. After the incident, she went to the police station and surrendered herself.
Entire allegations, my lord, is against A1.
Mm. It is
Because, my
all
lord,
because of you. It
she,
is all because of you.
but there is hatred between deceased and accused number 1.
Why
Deceased,
why you brought her to your house?
but we are in love.
That is why you are the root cause.
Maybe, but I am not a root cause for death. My lord, it is, my lord, it is A1, my lord, who murdered and surrendered before the police, saying that I have killed her.
You cannot take your own advantage of your own fault. When there is specific allegations.
Well, there is specific
But
allegation.
for your,
Well, I am standing there. Please.
but for your instigation.
There
she
is no
would not have
instigation.
come.
There is no instigation in the statements, my lord. ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
ಅಲ್ಲೇ
But
ಹೇಳಿದ್ದೇನೆ
ಅಲ್ಲಲ್ಲ,
ನೋಡೋದು
charge sheet
ಮತ್ತೆ
column 17 ಹೇಳ್ತಾರೆ, but statements ಅಲ್ಲಿ ಎಲ್ಲೂ ಹೇಳಲ್ಲ. No statements, you lordship, my lord. The lone eyewitness, my lord, is the daughter.
No. PM report ಎಲ್ಲಿದೆ?
Death is due to asphyxia on page 90. Death is due to asphyxia as a result of combined effect of smothering and pressure over neck, which is sufficient to cause death in the ordinary course of nature.
Page number?
Page number 90.
90.
90. No, my submission, my lord. Entire allegation is A1.
Yes.
And my lord, she there was hatred between my lord deceased and A1 only. I have no, my lord, no motive to kill her. I have not instigated her. It is only my lord, A1, my lord, who took the entire action, my lord, to murder deceased.
Yes.
I'm only, my lord, according to prosecution, I was standing there. I was present there.
Yes. Yes.
And he's in custody for the last 1 year, 6 months.
Mm.
And now charge sheet is filed, my lord, the customary.
Yes.
My lord, the petitioner, my lord, has conspired with the accused number 1 and assisted her in killing the deceased, my lord. The daughter of the accused, my lord, is the eyewitness, my lord. She's the CW20, my lord. Page number 62 is her statement, my lord.
Daughter of petitioner.
Daughter of accused number 1 and 2.
Eyewitness.
Yes, my lord.
What is her age?
Her age is 17 years, my lord.
Page number?
Page number 62, my lord. The relevant portion is at page number 63. From the 12th line, my lord. May I read, my lord? ಆಗ ನಾನು ಅವರಿಗೆ ಏನು ಮಾತನಾಡದೆ ಮನೆಯೊಳಗೆ ಹೋದಾಗ ನಮ್ಮ ಮನೆ ಹಿಂದೆ ಯಾರೋ ಜೋರಾಗಿ ಕಿರುಚಿದ ಶಬ್ದ ಕೇಳಿಸಿತು. ನನಗೆ ಹೆದರಿಕೆಯಾಗಿ ಬ್ಯಾಟರಿ ಹಿಡಿದುಕೊಂಡು ಮನೆ ಬಲಭಾಗದಿಂದ ಹೋದರೆ ಇಳಿಜಾರು ಇದ್ದುದರಿಂದ ನಾನು ಹೋಗದೆ ಹಾಗೆ ನಿಂತೆನು. ಅದೇ ಸಮಯಕ್ಕೆ ಕಿರುಚಿದ ಶಬ್ದ ಕೇಳಿ ನಮ್ಮ ಮನೆ ಎದುರು ಮನೆ ವಾಸಿ ಮಂಜಾ ಬೋವಿರವರು ಟಾರ್ಚ್ ಹಾಕಿ ನೋಡಿದರು. ಯಾರು ಕಾಣದೇ ಇದ್ದುದರಿಂದ ಅವರು ಮನೆಯೊಳಗೆ ಹೋದರು. ನಾನು ಮನೆಯೊಳಗೆ ಹೋಗದೆ ಸಣ್ಣಗೆ ಮಳೆ ಬರುತ್ತಿದ್ದರಿಂದ ನಾನು ಮನೆಯ ಬಲಭಾಗದಿಂದ ನಮ್ಮ ಮನೆಯ ಹಿಂದೆ ಗದ್ದೆಯ ಕಡೆಗೆ ನಡೆದುಕೊಂಡು ಹೋಗಿ ಟಾರ್ಚ್ ಹಾಕಿ ನೋಡಿದಾಗ ನನ್ನ ತಾಯಿಯು ಭಾರತಿಯನ್ನು ನೆಲದ ಮೇಲೆ ಮಕಾಡೆ ಮಲಗಿಸಿಕೊಂಡು ಬೆನ್ನಿನ ಮೇಲೆ ಕುಳಿತಿದ್ದರು. ನಾನು ಅಮ್ಮ ಏನಾಯಿತು ಎಂದು ಕೂಗಿದಾಗ ಅವರು ಕೈ ಸನ್ನೆಯಿಂದ ಲೈಟ್ ಆಫ್ ಮಾಡು ಎಂದು ಹೇಳಿದರು. ನಾನು ಲೈಟ್ ಆಫ್ ಮಾಡಿ ಸ್ವಲ್ಪ ಹೊತ್ತು ಅಲ್ಲೇ ನಿಂತಿದ್ದಾಗ ನನ್ನ ತಾಯಿಯು ಮೇಲೆ ಎದ್ದು ಬಂದರು. ನೆಲದ ಮೇಲೆ ಬಿದ್ದಿದ್ದ ಭಾರತಿಯು ಮೇಲೇಳಲೇ ಇದ್ದಾಗ ನನಗೆ ಹೆದರಿಕೆಯಾಗಿ ನನ್ನ ಅಮ್ಮನಿಗೆ ಮಾತನಾಡಿಸಲು ಹೋದಾಗ ಅವರು ನನಗೆ ಮನೆಯೊಳಗೆ ಬಾ, ನಾನು ಹೇಳುತ್ತೇನೆ ಎಂದು ಮನೆಯೊಳಗೆ ಕರೆದುಕೊಂಡು ಬಂದರು. ಮನೆಯೊಳಗೆ ಬಂದಾಗ ನನ್ನ ತಂದೆಯು ನೀನು ಹೆದರಬೇಡ, ಭಾರತಿಯನ್ನು ನಾವೇ ಸಾಯಿಸಿದ್ದೇವೆ, ಈ ವಿಚಾರ ನಮಗೆ ಬಿಟ್ಟರೆ ಬೇರೆ ಯಾರಿಗೂ ಗೊತ್ತಿಲ್ಲ, ನೀನು ಯಾರಿಗೂ ಹೇಳಬೇಡವೆಂದು ಹೇಳಿದರು. ನಂತರ ನನ್ನ ತಾಯಿಯು ಕೈಕಾಲು ತೊಳೆದುಕೊಂಡು ಕೆಸರು ಆಗಿದ್ದ ಬಟ್ಟೆಗಳನ್ನು ಬದಲಾಯಿಸಿಕೊಂಡರು. And also the neighbor, my lord, is CW21. Statement is in page number 64, my lord.
Yes.
The relevant portion is in page number 65. Second paragraph, my lord. After 10 lines, my lord.
Yes.
ಆಗ ನಾನು ಸಂಸಾರದಲ್ಲಿ ಅನುಸರಿಸಿಕೊಂಡು ಹೋಗುವಂತೆ ಹೇಳಿದ್ದು, ಈಕೆಯು ಸುಮಾರು ಹೊತ್ತು ನಮ್ಮ ಮನೆಯಲ್ಲೇ ಮಾತನಾಡುತ್ತಾ ಕುಳಿತು, ನಂತರ ಸಂಜೆ ಸುಮಾರು 7:30 ಗಂಟೆಗೆ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಅಡುಗೆಯಾಗಿದ್ದು ಊಟ ಮಾಡಬೇಕು ಎಂದು ಹೇಳಿ ಆಕೆಯ ಗಂಡ ಮಂಜುನಾಥನ ಮನೆಗೆ ಹೊರಟಳು. ನಾನು ಅವಳೊಂದಿಗೆ ಹೊರಗೆ ಬಂದಾಗ ಮಂಜುನಾಥನ ಮನೆಯ ಮುಂದೆ ಭಾರತಿಯು ನಿಂತಿದ್ದು, ಕಾಂತಾಳು ಮನೆಯೊಳಗೆ ಹೋದಳು. ನಾನು ವಾಪಸ್ಸು ಮನೆಯೊಳಗೆ ಹೋದೆನು. ರಾತ್ರಿ ಸುಮಾರು 8:30 ಗಂಟೆಗೆ ನಾವೆಲ್ಲರೂ ಮನೆಯಲ್ಲಿರುವಾಗೆ ಮಂಜುನಾಥನ ಮನೆ ಕಡೆಯಿಂದ ಯಾರೋ ಜೋರಾಗಿ ಕಿರ್ಚಾಡಿದ ಶಬ್ದ ಕೇಳಿತು. ಕರೆಂಟ್ ಇಲ್ಲದೆ ಇದ್ದುದರಿಂದ ನಾನು ಮನೆಯ ಹೊರಗೆ ಬಂದು ಬ್ಯಾಟರಿ ಲೈಟ್ ಹಾಕಿ ಸುತ್ತಮುತ್ತಲು ನೋಡಿದಾಗ ನಮ್ಮ ಮನೆ ಎದುರಿನ ಮನೆಯ ಮುಂದೆ ಮಂಜುನಾಥನು ಹೊರಗೆ ನಿಂತುಕೊಂಡಿದ್ದು, ಉಳಿದಂತೆ ರಸ್ತೆಯಲ್ಲಾಗಲಿ ಅಥವಾ ಸುತ್ತಮುತ್ತಲು ಯಾರೂ ಕಾಣಲಿಲ್ಲ. ಮಂಜುನಾಥನ ಮನೆಯೊಳಗಿಂದ ತನು ಸಹ ಹೊರಗೆ ಬಂದನು. ನಾನು ಏನೋ ಇರಬಹುದು ಎಂದು ಮನೆಯೊಳಗೆ ಹೋಗಿ ರಾತ್ರಿ ಊಟ ಮುಗಿಸಿ ಮಲಗಿಕೊಂಡೆನು. At that time, the petitioner was also present in the house, my lord. And he actively participated in the crime by assisting the accused number 1, my lord.
Yes. Not entered.
Lord, is that?
Petitioner.
Our charge sheet is filed, my lord, and is in custody for the last 1.5 years. And there is no serious overt act against.
ಮಗಳೇ ಇದ್ದಾಳೆ ಐ ವಿಟ್ನೆಸ್.
ಇದ್ದಾಳೆ. But serious overt act against accused number 1 only.
Let her be examined. Counsel, petitioner being accused number 2 is sitting at who have apprehended on 7/7/2023. Since then he is in judicial custody. Who is the complainant in this case?
Mother of the deceased.
Mother.
my lord.
The mother of the deceased filed first information regarding death of her daughter. And the FIR came to be registered against eleven persons. During investigation, it was found that accused number 1 and 2, being the wife and the husband, who committed the offense and by causing the death of the deceased by strangulating her neck. Charge sheet came to be filed. As per charge sheet, it is the contention of the prosecution that accused number 1 and 2 are the husband. The petitioner, being the husband of accused number 1, had relationship with the deceased, and he married her as his second wife. Accordingly, deceased started residing with accused number 1 and 2. Since the relatives of accused number 1 and 2 started evading them, as the petitioner was having this relationship with the deceased as a second wife, there was frequent quarrel in the house of the accused. On the date of incident, accused number 1 and 2 conspired together to cause the death of the deceased, and with a common intention, accused number 1 strangulated the neck of the woman, as a result of which she died. It is the specific contention of the prosecution that it was accused number 2 who is the petitioner hearing who conspired and instigated accused number 1 and also assisted her in causing the death. As per PM report, the death of the deceased was due to asphyxia as a result of combined effect of smothering and pressure over the neck. How many injuries were found?
9 injuries.
9 injuries were found on the dead body, and all 9 injuries were antemortem in nature. Antemortem and fresh in nature. Next, CW20 is the daughter of the petitioner and accused number 1. She is an eyewitness to the incident. As she has seen accused number 1 causing death of the deceased. And further, she also states that it was the petitioner who asked her not to reveal this fact to anybody else, as it was accused number 1 and 2 who have caused the death of the deceased. CW21 is the neighbor who has also seen the petitioner at the scene of occurrence at the time of incident, even though it was dark. There are strong prima facie materials against the petitioner for having committed the offence. Next, the contention of the learned counsel for the petitioner that it was only accused number 1 who caused the death of the deceased, and the petitioner has not played any role cannot be accepted in view of the statements of CW20 and 21, who are the daughter and the neighbor of the petitioner. Under such circumstances, if the petitioner is enlarged at this stage, it will have an adverse impact on the evidence that may be led by these material witnesses. Therefore, I am of opinion that the offence in question is punishable either with death or imprisonment for life. Yes. Negative of the following reason. Yeah.
Serial number 8.
Dismiss.
JBK.
The petitioner in this case. Is the petition under section 438 CRPC seeking the relief of anticipatory bail, my lord. My lord has been pleased to grant bail to accused number 2 and 3 in this matter.
Who is the petitioner?
Petitioner is accused number 1, my lord.
When he was arrested?
He has not been arrested, my lord.
438.
Please, my lord.
Then you said he was granted bail?
No, that is accused number 2 and 3, my lord.
In all,
My
how
lord
many
has
accused?
granted bail to 2 and 3.
In all, how many accused?
3 accused, my lord.
2 and 3 are on bail?
On bail, my lord.
Regular bail?
Anticipatory bail, my lord. 2 is the wife of accused number 3, my lord. Now, the offences alleged are 354B, 506, 504, 34, read with section 67A of the Information Technology Act, my lord.
Where is the bail order in favor of accused number 2 and 3?
My lord, it is at page 46, my lord, which is at annexure email.
1.
The same situation exists even today, my lord. She has not submitted herself to be examined by the police. No documents have been submitted. The phone is conspicuously missing, my lord. Now, I would like to draw my lord's time. Please, please. My lord.
Yes, what do you say? Parity. Yes, forward. Petitioner being accused number 1 is seeking grant of bail on the apprehension of being arrested. Page number 48 must be in the order. Sentence burden. For a finally, it is contended by the learned counsel for the petitioner that ಇಷ್ಟು ಬ್ರಾಕೆಟ್ ಹಾಕಿದ್ದೀನಿ ಅದಕ್ಕಿಂತ ಮುಂಚೆ attention was drawn to the order dated 30th October 2024, passed in criminal petition number 10535 of 2024, wherein accused number 2 and 3 against whom similar allegations are made or granted anticipated bail subject to conditions. Such circumstances, I do not find any reason to reject extending the benefit of parity in favor of the present petitioner. Accordingly, I answer. Yes, allowed.
Much obliged.
Number 9, Abhinaya, okay?
This matter, I seek 2 days time, my lord.
Your Lordship, I am on the ground of parity. Your Lordships have been pleased to grant bail to accused number 2 and 3.
Now she is seeking time.
Will be taken up on Fridays.
Friday. Friday.
Much to.
Friday not there.
Petition ಅಲ್ಲೇ ಆಗ್ತದೆ.
ಅಷ್ಟೇ. ಅದು ಇಲ್ಲದಿದ್ರೆ ಬರೀ ಕಂಪ್ಲೇಂಟ್ಸ್ ಅದು ಇದು ಅಯ್ಯೇ ಬರೀ ಇದು ಮಾತ್ರ ಹಾಕ್ತಿತ್ತು ಅಂದ್ರೆ ಅದು ಅಂತದ್ದು ಬೇಡ ಅಷ್ಟೇ. ಏನದು ಮುಂಚೆ ಮೂರಲ್ಲಿ ಅಂದ್ರೆ ಎಲ್ಲರೂ ಒಂದು petition ಹಾಕಿದ್ರು ಪಾರ್ಟಿ ನೋಡೋದು ಎರಡೇ ಅವರಿಗೆ ಯಾರು ಇಲ್ಲ ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್ ಅದರಲ್ಲಿ ತಗೊಳ್ಳಿ 17 list 1 serial number 17. Counsel for the appellant submits that needful is done. If PF with correct address is paid, issue notice to respondent. ನಲ್ಲಿ ಪೇ ಮಾಡಬೇಕು. ಅದರಲ್ಲಿ 45.5 ನಲ್ಲಿ ತಗೊಳ್ಳಿ. Then counsel for the petitioner seeks permission to comply with the office exceptions pending consideration of IA 1 and 2 of 2024. He is permitted to comply with the office objections. ಮಾಡೋದಿಲ್ಲ ಅವ್ರು ಇವತ್ತು ಮಾಡ್ತಾರ ಮಾಡಲ್ಲ ಮಾಡಿದೀವಿ 9 objections ಇದೆ ಅಂದ್ರಲ್ಲ ಇದರಲ್ಲಿ ಎಷ್ಟಿದೆ ಅದರಲ್ಲಿ ಆಯ್ತು ಅಂದ್ರೆ ಕಂಪ್ಲೈ ಆಯ್ತು ಅಂದ್ರೆ ನೀಡ್ಫುಲ್ ಅಂತ ತಗೊಳ್ಳಿ ಅದಿಲ್ಲ ಅಂತಂದ್ರೆ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತ ಒಂದು ಇಟ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ ಧಾರವಾಡ ನೋಡೋಣ ಅದೇನು ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಏನಾಗಿರ್ತದೆ ಮೊದಲಿಂದ ನೋಡೋಣ ಅದನ್ನು ಬರ್ಬೇಕಾದ್ರೆ ಹೇಳ್ತೀರಿ ಧಾರವಾಡ ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕು ಅದು ಮಾತ್ರ ಅಷ್ಟೇ ಬೆಂಗಳೂರಿಂದ ಯಾವುದು ಏನು ಬರಬೇಕಾಗಿಲ್ಲ ಅಷ್ಟೇ ಮತ್ತು ಧಾರವಾಡ ಅಂಗಡಿಯವರು ಕನೆಕ್ಟ್ ಆದ್ರೆ ಮತ್ತು PL ಪಾಟೀಲ್ ಬಂದು
Madam, 44